articles, that is Article 23 and Article 24. Here Article 23 prohibits forced labor, bonded labor, trafficking in human beings. Human beings include men, women, children, any person. So we've talked about trafficking in human beings is immoral, illegal. We have prohibited such activities under Article 23. Under Article 24, we focus specially on children. This article talks about children. Children under the age of 14 years, and when we say adolescents, between 14 and 18 years of age. So ఈ ఆర్టికల్ 24 అనేది పిల్లల గురించి మాట్లాడుతుంది. ఆర్టికల్ 23 అనేది అందరూ హ్యూమన్ బీయింగ్స్. సో హ్యూమన్ బీయింగ్స్ ఇస్ ఆర్టికల్ 23 అనేది ఎక్స్ప్లాయిట్కి అగేన్స్ట్గా మనకు ఆర్టికల్ ఉంటుంది. ఇది చిల్డ్రన్స్ని కొన్ని పరిస్థితిలో ఎక్కడ హజార్డస్ అంటే డేంజరస్ ఉన్న సిచ్యువేషన్స్లో వర్క్ చేయించకూడదు. ఫర్ ఎగ్జాంపుల్ కన్స్ట్రక్షన్ వర్క్ కానివ్వండి, రైల్వేస్, పోర్ట్స్, మైనింగ్స్, బీడీ అండ్ సిగరెట్ కంపెనీస్, అలాంటి హజార్డస్ ప్లేసెస్లో పిల్లల్ని ఎంప్లాయ్ చేయకూడదు అనేది ఈ ఆర్టికల్ యొక్క ఉద్దేశం. వీ హ్యావ్ ప్రొహిబిటెడ్ ఎంప్లాయ్మెంట్ ఆఫ్ చిల్డ్రన్ ఇన్ ఫ్యాక్టరీస్. Article 24. What are those factories? Actually, we have prohibited employing children. So it prohibits. Article 24 prohibits the employment of the children below the age of 14. As I said, below the age of 14, we treat children. Just to remind you, when we talk about Article 21A, right to education, this article makes it compulsory to send children to the schools between the age of 16 to 14 years. Every child in the age of 16 to 14 years have to be enrolled in schools. That is right to education is. But here we are, in certain cases, we are prohibiting the children to work in any factory, mine and hazardous. When we say such children can support their family in agriculture, in their domestic works, who are children like below 14 years of age, but they should not work in these factories because these are hazardous. People of low age, that is children, cannot take the load of these factories. There may be chemical factories which could harm their health or their vision. Anything could happen in these factories, mines and such hazardous places. So this article prohibits employing children below age of 14 in these hazardous places. So the Child Labor Prohibition and Regulation Act has strengthened Article 24. We have a Child Labor Prohibition and Regulation Act. So we need to know what child labor is. One thing is, in many factories, children are employed because children could not demand for more salary. They will work for hours together without any fatigue, without any tiredness, and they will not form unions obviously. So child will sit for hours together. For example, if you take BD and cigarette workers, their children will be suitable. So this act prohibits such work by children. So it bans child labor. Employment of children in such hazardous places are banned. Rather, now we have banned children working in dhabas, restaurants or any other places like domestic work as well. We have banned children below age of 14 working in any place. So what we have generally in our society, where a family would employ their children for economic needs. So a parent will bring their children to the work so that they could earn little things because of poverty, because of illiteracy and all. So on economic basis, they can be employed full-time or part-time. So this practice, the practice of child labor, will deprive their childhood. వాళ్ళ యొక్క బాల్యాన్ని హరిస్తుంది ఈ యాక్టివిటీ, చైల్డ్ లేబర్ అనేది. ఈ బాల కార్మిక వ్యవస్థ అనేది వాళ్ళ బాల్యాన్ని హరిస్తుంది. వాళ్ళు సరిగ్గా ఎడ్యుకేషన్ తీసుకోకపోతే, సరిగ్గా చదువుకోకపోతే వాళ్ళ ఫ్యూచర్ అంతా అంధకారమయ్యే ఛాన్సెస్ ఉన్నాయి. సో కీపింగ్ ఇన్ వ్యూ ద ఫ్యూచర్ ఆఫ్ ద చిల్డ్రన్, the future of the society, the future of the nation, we have brought many acts which prohibits employment of children in any sector. So for a healthy mind, the children should be in school in that age so that later he could settle in a much better way and build the nation. He would be a part of nation building. So this act, again we had an amendment. This act has been renamed as child and adolescent labor because we have added this word adolescent. Adolescent is where the children is between the age of 14 and 18. So we have renamed this act and we have added the word adolescent. So this act, Employment of Children Act, this act regulates the employment of children in certain industrial employments. We have few sectors, we have 18 such companies which is notified. So the Factories Act is the principal legislation which governs the health, safety and welfare of the worker in the factory. So it is applicable in entire India. So this act also prohibits employment of children, that is, it bans child labor. So we have many things in our culture where small children are employed in factories. They are not paid as per their work. So a lot of exploitation was happening here. So many legislations were brought. But unfortunately, we still experience such practices in which is not coming out. No one, takes these matters, or we can say the employer, for his greed, for not paying more amount to elders, they will employ children. So this is unfortunate thing. So here we say Child Labor Amendment 2016. In this we have added adolescent also, that is from 14 to 18 years of age. So this in this act, children below 14 years are prohibited to work anywhere, but we have 18 occupations and 65 processes. This is the areas where they cannot work. These are the hazardous occupations which is notified. They cannot work. So stringent punishment is made when some people, if anyone employs child labor, there is a stringent punishment. Punishment could be for 6 months to 3 years. If the same person repeats that crime of employing a child labor, he could be jailed for 3 years and he could be penalized, or the fine would be 20,000 to 50,000 rupees. This act also mandates, establishment of a child fund where the amount which is collected from the fines is deposited in that fund, children's fund. So imprisonment is from 6 years to 2 years. If the crime is repeated, then up to 3 years. And fine is between 20,000 to 50,000. So we said that repeated offences is 3 years. The maximum punishment is 3 years of imprisonment. So we have a case, MC Mehta versus Tamil Nadu case. In this case, the employment in hazardous places are prohibited. There was also case Bandhuwa Mukti Morcha versus Union of India 1997. This case has said that the government should establish a fund, and whatever the amount or fines collected by the person who has employed those children should be deposited in this fund, child fund, and there should be a commission. There should be a commission for the protection of child rights. So on this advice, we have established National Commission for the Protection of Child Rights. We have established State Commission for the Protection of Child Rights, and we also have Special Children's Court, because we have seen many cases piling up in general ordinary courts. So for children's cases, there need to be a special children court. So all these commissions will regulate or will guide and will ensure that no children is employed in hazardous places, or the implementation of this law is ensured that such activities is not repeated. So that was Article 24, where we talk about abolition or prohibition of child labor. So here, when we say right against exploitation under fundamental rights, is an important area where human beings and especially children in Article 24 are treated with dignity. Child labor is totally prohibited. Even now, no child labor, no child should work in domestic places also. So child labor in domestic, you forget about all those hazardous places, factories, mines, construction works, railways and all. In domestic also, the child below the age of 14 is not employed. It is being prohibited. So there are many cases where people say, for example, we have child artists working in cinema, serials, stage shows, or also going with parents to help, to be helpful for their occupation. So there are many cases, and Supreme Court said that if they are enrolled in school and their basic things are not violated, they can employ in certain sectors like cinema, TV serials and all. So that is not exploitation. That is they are being recognized for their skills, for their art. So the employer should take all those precautionary things while employing. They should not disturb their privacy. They should not be exploited. They should not be get away something like they don't need to go to school and such things. They have to be properly enrolled in the school. No study hours should be disturbed. So these precautions the employer should take before signing a contract. So child labor is not a child labor. It doesn't come under the child labor where the children is acting in cinemas or serials, such things. So generally Article 24 talks about child labor, prohibits employment of children in factories, and Article 23 talks about prohibition of traffic in human beings. It's a very larger, very comprehensive word, trafficking in human beings. That means treating human beings as a good. So selling, buying is prohibited. It also prohibits slavery, Devdasi system, bonded labor, etc. So this Article 23 and 24 are important regarding human dignity, their employment, their remuneration, wages, conditions of work, etc. We will be discussing Article 33, Article 34 and Article 35. So Article 33. So in this fundamental rights, continuing with our fundamental rights, what is Article 33? This Article 33 is applicable to certain section of the people. That is, Article 33 gives power to the Parliament to curtail or to limit certain fundamental rights to certain sections of the people. Here when we say certain section of the people, they are not a normal citizen. They are personnel who is involved in armed forces. Sayuda Dalalu. So these people work in armed forces. Armed forces also includes army, military, that is army. They also includes paramilitary forces, police personnel, and other personnel who is working in intelligence, like we know intelligence bureau, we know raw research and analysis wing. So all those personnel who are engaged in protecting law and order, in protecting lives of the people, in protecting and ensuring that the security of the state is protected. So armed forces here are basically Indian Army, Indian Navy, Indian Air Force, and we know paramilitary forces. Even paramilitary forces are also included in armed forces. Just to have a brief idea, armed forces under Article 33, it empowers the Parliament to limit or to place restrictions on the fundamental rights for the persons involved in armed forces. ఎవరైతే ఆర్మ్డ్ ఫోర్సెస్లో ఉంటారో సాయుధ దళాలు, వాళ్ళకి ఒక పార్లమెంట్ ఒక పవర్ తీసుకుంటుంది. ఆ పవర్ ద్వారా వీళ్ళని ఫండమెంటల్ రైట్స్, ప్రాథమిక హక్కులపైన కొద్ది నియంత్రణ పెట్టడానికి ఈ ఆర్టికల్ పార్లమెంట్కి ఎంపవర్ చేస్తుంది. At the same way, we know martial law. This is under Article 34. Martial law, సైనిక చట్టం. This law is different from ordinary law. We have many ordinary law. We have many laws which are passed by Parliament, implemented by executive agencies. But this is different. Martial law is a special law where the administration, that is the civil administration, is completely taken over by military. That is, there is a military law, or we can say military rule. This word martial law we have taken from England, that is English. What happens when martial law is imposed? The general administration, that is the civil administration, does not function as per the ordinary law. So here military rule will prevail. So under military rule everything will be changed. Ordinary laws are temporarily suspended. This is what we discuss in Article 34. That is, Article 34 empowers military to govern the place where that martial law is implemented. And what is Article 35? Affecting certain fundamental rights. Chattabadhata Sikshana. We just have a revision that we also said fundamental rights are of two types. One, some are self-executory. Some fundamental rights are self-executory. That is, they get to be implemented on its own. And some fundamental rights should have a law, a prescribed law to get implementation. So that is the Parliament. Parliament is the sovereign authority to pass certain law to implement certain fundamental rights. So not all fundamental rights are implemented on their own. Some are self-executory and some have to be implemented by certain laws. And it is the Parliament which executes or which formulates these law and bring a rule or bring a law on which certain fundamental rights are being implemented. And we also have certain fundamental rights where the court has to punish, or there is a detailed explanation that if any fundamental law or fundamental right is violated, then there have to be some punishment. For example, we know that if there is an untouchability under Article 17, we have prohibition of untouchability. If any person involves in the process of untouchability, then he will be penalized or he will be punished. For example, we have child labor. If anyone admits a child and makes him to work against their interest, then he is penalized, he is punished. So all those laws which penalizes a person are under this act. So Act 35, that is, according to this article, it will empower the parliament to bring certain law and also to determine what kind of punishment is given if anyone violates such law. So basically we have these three types. Here Article 33 empowers the parliament to restrict certain fundamental rights on these armed forces. And martial law, again it is the right, it is the power of the parliament to impose martial law when there is a threat to law and order of the society, or if there is a threat to the security of the state, or there is a threat to the integrity of the state. So martial law is imposed when ordinary law is break down, when there is a need to restore the law and order and peace. And Article 35 empowers Parliament to bring certain laws and also decide the nature of the punishment if any fundamental right has been breached. So briefly, we have to know this Article 33, 34 and 35. Getting into the details. So Article 33, as we said, it empowers the Parliament to restrict or obligate or curtail certain fundamental rights or fundamental rights to these sections of the people. Obviously, armed forces are not ordinary personnel. They are the forces involved in protection of people, protection and safeguarding our boundaries whenever there is a war or external aggression. So armed forces people means we have three kinds of armed forces in general, that is army, we have navy and we have air force. So armed forces generally they are army, navy and air force. So they are involved in protection of the nation, protection of our boundaries from external aggression or war. They have their own rules, they have their own laws, or they are different from what a common man, a common citizen is. So obviously they do not enjoy all those fundamental rights which in general are enjoyed by ordinary people. We also say paramilitary forces. They are also armed forces, but their duty is to protect the lives and property of the people. So paramilitary forces are of various types generally. We know CISF, Central Industrial Security Force, CRPF, Central Reserve Force, we have Indo-Tibetan Border Post, we have BSF, Border Security Force, Sashastra Seema Bal, SSB, Assam Rifles. So we have different kinds of paramilitary forces which are engaged in protection of life, safety and property of the citizen of India. They are also supplemented in protecting the national boundaries. And we have police forces. Generally we see, we have police is under state list. State law and order is controlled by the state administration. So police, in police also we have law and order, we have intelligence, we have crime bureau, we have special police, we have reserve police. So many kinds of police forces working for the safety and security of the people, working for the protection of law and order. So all these forces can not enjoy the same fundamental rights as common people does. So fundamental rights are not equally applicable to all these personals. When we say intelligence agencies, even these are also come under armed forces or police forces, because they also involve in security of the state, for protection of the security of the state. So in intelligence we have Intelligence Bureau, we have Research and Analysis Wing and many other agencies. So Article 33 empowers Parliament to contain or to put restrictions on these forces or these personnel in the enjoyment of fundamental rights. So they cannot demand for the fundamental rights. So if there is any fundamental right which has been abridged or which has been taken away, the armed forces cannot move the court saying that our fundamental rights has been abridged. So to limit, to contain their fundamental rights, Parliament has the sovereign power, and we can say that Parliament has an exclusive power in containing or putting restriction on fundamental rights for these personnel. Why it is only Parliament? Why it is not state assemblies? Because defense is a subject which comes under central list, that is union list. And as defense is a subject under union list, only Parliament has the authority to create such laws and which is applicable throughout the territory of India. So for the application of uniformity under this law, only Parliament has the power to impose restrictions on these agencies. సో ఆర్మ్డ్ ఫోర్సెస్ కానివ్వండి, పారామిలిటరీ ఫోర్స్, పోలీస్ ఫోర్స్, ఇంటెలిజెన్స్ ఏజెన్సీస్, వీటిలో పనిచేస్తున్న సాయుధ దళాల యొక్క ప్రాథమిక హక్కులపైన నియంత్రించే పవర్ ఓన్లీ పార్లమెంట్కి మాత్రమే ఉంది. ఎందుకంటే పార్లమెంట్ ఈజ్ ద సుప్రీం అథారిటీ విచ్ ఈజ్ ద హైయెస్ట్ అథారిటీ టు పాస్ అ లెజిస్లేషన్ విచ్ ఈజ్ అప్లికబుల్ త్రూ అవుట్ ద టెరిటరీ ఆఫ్ ఇండియా. సో ఆర్టికల్ 33 అనేది స్పెషల్ ఫోర్సెస్, ఈ ఆర్మ్డ్ ఫోర్సెస్, పోలీస్ కానివ్వండి, పారామిలిటరీ ఫోర్స్ కానివ్వండి, వాళ్ళ యొక్క ప్రాథమిక హక్కులను నియంత్రించే అంశము. విల్ మూవ్ ఆన్. సో వై వీ నీడ్ టు రెస్ట్రిక్ట్ దీస్ ఫండమెంటల్ రైట్స్? ద మెయిన్ రీజన్ టు కంటైన్ ఆర్ టు రెస్ట్రిక్ట్ దిస్ ఫండమెంటల్ రైట్స్ for all these sections of the people is that to ensure their proper discharge of duties. Here, when we say to ensure the proper discharge of the duties, if just assume if those personnel having all the fundamental rights, what generally their nature of job is to work for many hours in a day, to work in harsh conditions, some of the time they won't be getting leave, so they cannot move court for implementation of fundamental rights because it is the nature of the duty that demands something extraordinary from those people. So these people or the personnel who is working under armed forces will obviously do not have such freedom as common people enjoy. For example, we say a common people, a common citizen under Article 19 Clause 1, he has all the freedom to speak, to express, to form assembly, to form union, to move anywhere throughout the India. So all these things a police personnel or armed force personnel cannot enjoy. A military officer cannot have a press meet voluntarily. He cannot speak whatever he wants to speak. They cannot form unions. They cannot participate in political rallies. They cannot participate in demonstrations. So generally thinking, armed forces, be it paramilitary force, police force, intelligence, all these personnel do have their certain limitations. Once they entered into the job, they have to follow certain rules which are obviously very strict rules. So common ga ఈ ఆర్మ్డ్ ఫోర్సెస్ అంతా మనము సాయుధ దళాలు, పోలీస్ కానివ్వండి, పారామిలిటరీ కానివ్వండి, ఇంటెలిజెన్స్ కానివ్వండి, వారు ఒక అగ్రిమెంట్ ఉంటుంది వాళ్ళకి. ఆ జాబ్లో ఎంటర్ అయిన తర్వాత వాళ్ళు ఈ ప్రాథమిక హక్కులు అనేది పూర్తి స్థాయిలో ఒక కామన్ సిటిజన్ ఎంజాయ్ చేసినట్టు ఎంజాయ్ చేయలేరు. బికాస్ వాళ్ళు చేసే వృత్తి అలాంటిది. ద నేచర్ ఆఫ్ జాబ్ డిమాండ్స్ దెమ్ టు హ్యావ్ restrictions on fundamental rights. That is the reason why Parliament is empowered to put restrictions on personnel of armed forces. That is one thing, because to discharge their duties properly and to have discipline among themselves. When we say generally a fundamental right is a person should not work, like they have to provide a decent livelihood, that is not to work beyond 8 hours or 12 hours. The same thing we cannot apply for armed forces. So to bring or to instill discipline among them, Parliament could curtail or could restrict certain fundamental rights. And this power, that is under Article 33, power to restrict fundamental rights and its applicability is given to only Parliament and not state legislature. Only Parliament has the power to put restrictions on fundamental rights of armed forces. So, states cannot pass any law regarding fundamental rights, and Parliament has passed many legislations, or it has brought many laws which restrict fundamental rights of armed forces. We have Army Act 1950, Navy Act 1950, Air Force Act 1950, and we have many acts regarding police forces, restriction of rights, that is a policeman cannot participate in political rallies, cannot make himself involved with any political party. They do not have unions, they cannot go on strike, they cannot demand for a leave, because that is the nature of their job. When everyone enjoys the fundamental rights, armed personnel or police personnel will work without questioning on their fundamental rights. They can't even move Supreme Court regarding exception of certain fundamental rights. So these officers do not enjoy all fundamental rights what a common citizen will enjoy. So many acts brought by the Parliament, border security force, we have military law. So these are the laws which have brought by Parliament. So that is Article 33. And one thing we need to know, that Article 33 is restricting fundamental rights of armed forces. They are talking about personnel. So Article 34 talks about fundamental rights and restrictions within a area, within a place. So here area means martial law is imposed in certain place where there is a breakdown of law and order. Whenever there is a breakdown of law and order, or there is a disturbance in kind of violence, in kind of riot or anything, in that situation, if the problem or the violence is not in control by police administration, that is local police, then the Parliament has the power to impose martial law in such places. So martial law is imposing a military rule. We know what military rule is. In military rule, the civil administration is completely taken by military authorities. So for temporary period, the civil administration comes in the control of military authorities or military. So we cannot expect a common or a civil administration to work, because to restore the peace or to restore the law and order, there have to have some kind of force to stop the force which has created the violence. So to repel that violence, we need to have a same kind of force to restore and to maintain the peace and stability, the tranquility and harmony of that particular place. So that is the need of martial law. Again, to not confuse the martial law with national emergency. National emergency is of different kind. Martial law is generally imposed in certain parts of the area, or we can say in certain part or a district of the state which is disturbed by certain miscriminants or a social evil factors. So there may be a violence regarding communal things, there may be a mob violence, there may be a small disturbance where there is a threat to law and order or life and property of the common people. So to contain these activities, these violent activities, immediately there is a need to impose martial law to restore the law and order. Generally, we've seen this in areas of sensitive disturbances. For example, in northeastern states, in states like Jammu Kashmir, in places which are bordering to our neighboring countries like China, Pakistan, Bangladesh, etc. So martial law is generally imposed to restore peace and stability. మార్షల్ అనేది ఒక సైనిక చట్టం. ఒక కామన్ అడ్మినిస్ట్రేషన్ ఫెయిల్ అయితే, వాళ్ళ అడ్మినిస్ట్రేషన్లో ఫెయిల్ అయితే మార్షల్ లా ఇంపోజ్ చేయడం జరుగుతుంది. మార్షల్ లా పెట్టిన తర్వాత, సైనిక చట్టం అక్కడ అమలు చేసిన తర్వాత సివిల్ అడ్మినిస్ట్రేషన్, మామూలుగా ఒక సివిల్ అడ్మినిస్ట్రేషన్ అనేది కంప్లీట్లీ మిలిటరీ చేతిలో వెళ్ళిపోతుంది. సో దిస్ ఈజ్ వేర్ దేర్ ఈజ్ అ టెంపరరీ సస్పెన్షన్ ఆఫ్ సివిల్ అడ్మినిస్ట్రేషన్. So Article 34 empowers the Parliament to restrict fundamental rights. Here Parliament has all the power to restrict fundamental rights of people, of general people who are living in the area where there is martial law. We can say that in any district, if martial law is imposed, the people living there cannot go to the court, cannot approach the court saying that our fundamental right to move freely has been taken away. Because in extraordinary conditions, such steps has to be taken by the central government to restore the peace or to stop the violence and to protect the property and lives of the common people. So under military law, fundamental rights are restricted for the common people, of their people. So this also empowers the Parliament to protect the officers who are involved in martial law. They are government officers, be it military officers or any such officer. The government will protect their actions so that they could work independently, they could work with some confidence. That is what we call indemnify. The government will indemnify those officers or those people involved in protection of law and order or who are part of armed forces or military. So it empowers the Parliament to indemnify any government servant for any act where it is needed to maintain the law and order. For example, in certain conditions, in martial law is prevailing there, if martial law is imposed on certain part of the country, so the common man there cannot move freely. What if a common man or a person comes out and shouts slogans against the country? Then definitely there will be some force done by officers, and that person who has been injured or who has been died, he or anyone behalf of him cannot move Supreme Court, because under martial law those civil administration is temporarily suspended. So government, that is the central government, that is the Parliament, has the power to impose restrictions on fundamental rights of people too. So when we say Article 33, it empowers Parliament to impose fundamental rights and restrictions on fundamental rights on certain sections of the people, that is armed forces, paramilitary forces, police forces, intelligence agencies. Here it is talking about personnel, that is person. In Article 34, the restriction is imposed on a place. So that particular place is under martial law. So any actions occurring on that place and where fundamental rights has been abridged, government is not providing any guarantee for the fundamental rights or abridge of the fundamental rights. That common man cannot move Supreme Court or High Court either. So that is what we call martial law, Sainika Chattam. Martial law is also called military rule. It is a military rule. We have brought this from English. So just not imposing restriction on fundamental rights. Parliament has the power to make sure that whatever the action is done by that personnel or by the armed forces is validated. Parliament says that all actions, whatever actions the officers have taken, like punishing someone or making someone forfeiting their property, taking away their rights, all these actions is validated. So whenever there is a martial law in certain part of the country, there the government validates the actions of the police personnel or military personnel. All these actions cannot be challenged in the court. So when martial law is imposed on certain section or certain part of the country, whatever happens there may be many things, fundamental rights may be breached, certain sections of the people may go to court, thinking to go to court for the breach of their fundamental rights, but such cases are not entertained by the court under martial law when the martial law is imposed there. Otherwise, under general conditions, under ordinary conditions, any person who has got breached their fundamental rights or their fundamental rights is violated, then such person can move Supreme Court under Article 32 and can move High Court under Article 226. That is under normal conditions, that is under ordinary conditions. But when in emergency conditions, when there is martial law applicable there, no person could move court saying that my fundamental rights has been breached. This harsh step by central government is to restore as soon as possible, as early as possible, to bring normalcy in that area. Otherwise, it may lead to further difficulties, or there may be a threat to life of the people, there may be a threat to property. So to restore normalcy, generally central government will resort to martial law, which is a necessary under circumstances. So this martial law is borrowed from English common law. No one can challenge that their fundamental rights are breached under martial law. So martial law ante military law. ఇలాంటి పరిస్థితిలో మార్షల్ లా ఎప్పుడైతే విధిస్తారో అప్పుడు పౌర పరిపాలన, దట్ ఈస్ సివిల్ అడ్మినిస్ట్రేషన్ ఈజ్ కంప్లీట్లీ టేకెన్ అవే బై మిలిటరీ. పౌర పరిపాలనను సైనిక అధికారులు నడుపుతున్నారు. అంటే ఎవ్రీథింగ్, ఆల్ ద సివిల్ అడ్మినిస్ట్రేషన్స్ హ్యాస్ బీన్ టేకెన్ ఓవర్ బై military people. So what military people generally do, they have their own rules, they have their own rule book, own style of working. So they generally follow their rules and regulations framed under their law. So when we generally impose martial law, as I said, martial law అనేది extraordinary circumstances మాత్రం లో వాడతారు. కామన్గా ఆర్డినరీ నార్మల్సీ ఉన్నప్పుడు, పబ్లిక్ పీస్ కరెక్ట్గా ఉన్నప్పుడు మార్షల్ లా అనేది యూజ్ చేయము. బట్ ఎక్కడైతే నేషనల్ సెక్యూరిటీకి థ్రెట్ ఉందో, కామన్ సిటిజన్ వాళ్ళ లైఫ్ ప్రాపర్టీకి థ్రెట్ ఉందో, అలాంటప్పుడే మార్షల్ లా మనం విధించవచ్చు. సో మార్షల్ లా ఈజ్ ఎక్స్పోజ్డ్ ఆర్ ఇట్ హ్యాస్ బీన్ applicable in certain circumstances. That is when we have war, when there is a threat of invasion. When there is a threat of invasion, that is when the neighboring countries has invading our country or few parts of the boundaries. When there is a rebellion within the country. So in these circumstances, when we say riot, it's a kind of violence, be it communal violence, be it mob violence. So under these circumstances, when normal law and order managed by the police, state police, is failed, so there is a situation which had gone beyond the state police authority or control, then martial law is imposed. So when state police says that this situation is not under our control, the battalion will come, the military people will come and take over the charges of that area. So entire civil administration is taken over by military authorities, and when that administration is under military, their military rule will apply, and military rule is not similar to ordinary rules. They have some extraordinary power. They could use some harsh methods to bring the normalcy in certain areas. So these people have given special powers. For example, we have Armed Forces Protection Act. So Armed Forces Special Protection Act is an act where these armed forces is being protected by the government. Their action cannot be questioned in the court. So they generally given more powers, that is extra powers, to limit the situations or to contain the situations which could at sometimes go beyond the control. It could lead to further damage for the security of the state. So Parliament is empowered to bring certain laws and empower personnel to act without any fear. So why martial law? As we said, martial law is imposed to restore the normalcy. That is, once there is a breakdown of law and order, with the same force, martial law would bring normalcy. That is, they repel by force to stop violence, to stop mob. The same kind of force should be used. It could be harsh, it could take away fundamental rights of many such people. Many people or citizen of that place could be arrested and detained. Many people could face lathi charge or similar things. They cannot go to court saying that our fundamental rights has been breached, because here there is a martial law. We do not have an ordinary law, and ordinary legislations cannot work when there is imposition of martial law. So the Supreme Court held, sometimes the Supreme Court also says that mere applicable of martial law cannot take away the fundamental right of issuing habeas corpus. Habeas corpus is a type of writ. Habeas corpus is where a Supreme Court or High Court empowered to issue writ to bring the body. That is, when there is an illegal detention, the court could issue writ. So just application of martial law doesn't take away the power of issuing writ. Declaration of martial law under this article, which is different. See, martial law, as I said, application of martial law is different from national emergency. National emergency, which is imposed under Article 352, is quite different. National emergency could be imposed on entire country or some parts of the country, but martial law is imposed for a specific reason. It is more applied in a small geographical entity or a small area where there is a breakdown of local law and order. So we have a difference in Article 34, that is martial law, and Article 352, that is national emergency. National emergency is imposed where we have a threat to security of our state at large, where there is a war, external aggression. So declaration of martial law, where we have to know the difference between martial law and national emergency. The difference is, in martial law, only fundamental rights has been taken away, or this affects only fundamental rights. సైనిక చట్టము విధించినప్పుడు మన ప్రాథమిక హక్కులను మాత్రమే ఎఫెక్ట్ చేస్తుంది. అదే నేషనల్ ఎమర్జెన్సీలో, దట్ ఈస్ అండర్ ఆర్టికల్ 352, మెనీ థింగ్స్ ఇంక్లూడింగ్ ఫండమెంటల్ రైట్స్, సెంటర్ స్టేట్ రిలేషన్ ఈజ్ ఎఫెక్టెడ్. ద financial relation between center and state, be it revenue sharing, grant in aid, all these things are restricted when we apply national emergency under Article 352. It's not only fundamental rights, but center state relations, legislative powers between center and state, and also there can be extension of tenure of the parliament when national emergency is imposed. That is not happening in martial law. Martial law only affects fundamental rights. So in martial law, the difference is this suspends the government and ordinary law courts. Ordinary law courts are also suspended because we have a need to restore the normalcy or bring the public order and peace and harmony back. Here in national emergency, ordinary courts are functioning. There is nothing to do with ordinary courts. Ordinary courts will generally function. And martial law is imposed when there is a breakdown of law and order to restore the normalcy. The damage has already done. To restore law and order, to prevail harmony, martial law is imposed. It can be imposed on 3 grounds. When I talk about national emergency, generally this is imposed on 3 grounds: war, external aggression, and armed rebellion. On 3 grounds under Article 352, national emergency could be imposed. So national emergency can be imposed on whole part of the country, that is on entire country, or on certain part or any part of it. So it is not that national emergency means it is imposed on entire country. Where we have a threat, certain places, on such places only national emergency could be imposed. And here it is imposed on specific area of the country. It is only imposed on the specific areas of the country. Martial law as national emergency cannot be imposed on entire country. So సైనిక చట్టం అనేది కొన్ని ప్రాంతాలు మాత్రమే పరిమితం అవుతుంది. ఎక్కడైతే నార్మల్సీ ఉండదో, పబ్లిక్ ఆర్డర్ ఫెయిల్ అవుతుందో అక్కడ మాత్రం మనము మార్షల్ లా విధించవచ్చు. అదే నేషనల్ ఎమర్జెన్సీ అనుకోండి, అది మొత్తం కంట్రీకి కానీ కొన్ని ప్రాంతాలకి మాత్రం విధించవచ్చు. సో as we have seen, martial law is nowhere explained in our constitution. It has not been defined anywhere in our constitution. It is implicit in Article 34. 34 మాత్రమే చెప్తుంది మనకి మార్షల్ లా గురించి. We have no specific provisions regarding martial law, but it is clearly mentioned in Article 352 about national emergency. We have a detailed explanations. We have a provisions regarding Article 352. So this is the difference between martial law and national emergency. Again, I need to reiterate that martial law is imposed to restore normalcy as soon as possible and to minimize the damages caused for both life and property of common people. Okay, the main difference between Article 33 and 34. So when we say Article 33 is to restrict fundamental rights and its applicability on certain section of the people. Article 33 empowers the parliament to impose restrictions to curtail fundamental rights on certain sections of the people, that is armed forces, paramilitary forces, police personnel, intelligence agencies, etc. So this is basically on certain section. ఆర్టికల్ 33 కొన్ని వర్గాల ఉద్యోగులకు మాత్రమే వాటి హక్కులను నియంత్రిస్తుంది. సో వాళ్ళ మెయిన్ ఫండమెంటల్ రైట్స్ని కంటైన్ చేస్తుంది. సో హియర్ సెక్షన్ ఆఫ్ ద పీపుల్, కొంతమంది వర్గాలకు మాత్రమే. 34 అనేది ప్రాంతాలకు సంబంధించింది. మనం ఎక్కడైతే సైనిక చట్టం అమలు చేస్తామో ఆ ప్రాంతానికి మాత్రం అక్కడ నివసిస్తున్న ప్రజల యొక్క హక్కులని నియంత్రించడానికి. So Article 33 is about section of the people, vargalu. Article 34 is about the geographical entity or the place where that martial law has been imposed, that is prantalu. So that is the main difference between Article 33 and 34. 33 talks about certain section of the people and 34 talks about that particular place where martial law has been imposed. And important again, Article 35, which is the last right under fundamental rights under Part 3. So this right, that is Article 35, empowers the parliament to bring certain laws or to frame certain laws to implement these fundamental rights. ఫండమెంటల్ రైట్స్ని, ప్రాథమిక హక్కుల్ని ఇంప్లిమెంట్ చేయడానికి కొన్ని చట్టాలు అవసరము. సో పార్లమెంట్ అలాంటి చట్టాలని తీసుకోవడానికి ఆర్టికల్ 35 ఎంపవర్ చేస్తుంది. సో ఆర్టికల్ 35 empowers the parliament to bring certain laws for implementation of the fundamental rights. As I said, all fundamental rights are not self-executory. For few fundamental rights, there has to be a backup of legislation. So that is one thing where Article 35 empowers the Parliament to bring certain laws for the applicability or implementation of fundamental rights. And it also empowers the Parliament to decide on the nature of the punishment given when someone is indulged in violation of fundamental rights. So శిక్ష ఎంత పడాలి ఒకవేళ ఒక పౌరుడు ఫండమెంటల్ రైట్స్ని అధిగమించడం జరిగితే, ఇఫ్ సమ్వన్ వైలేట్స్ fundamental rights or some state or some agency violates fundamental rights, then what kind of punishment is imposed? That is also decided by the parliament. Parliament will bring such laws where what kind of punishment is to be given for that particular agency, be it a person, state or any corporation which is involved in abrogation of the fundamental rights. So Article 35 ensures that the fundamental rights are implemented or its nature, its scope is uniform throughout the nation. So to bring that uniformity, it is only Parliament, that is Parliament is the sovereign authority in our country which has the ultimate power to decide or to make law which is applicable in entire territory of India. So only Parliament could decide on such laws, and it also prescribe certain punishments. So to ensure that there is a uniformity throughout the India with regard to the nature and the punishment, this is also given by Article 35. Article 35 decides that how much punishment should be given, what kind of punishment should be given. For example, in case of child labor, if a person employs a child below 14 years of age, then he will be punished with a fine of from 20,000 to 50,000, and he will be sent to prison for 2 to 3 years of term. So this is decided by the legislature. When the legislation is made, when the policy is formulated, every simple details will be there in that legislation. So Parliament will also bring laws and also prescribe punishment for the violation of such law. So we have certain things. Article 16 says there should be a equal opportunity in public employment. So in certain things Parliament will bring certain laws. So even writs, we have 5 kinds of writs. We have writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto, ఇలాంటి చాలా రిట్స్ ఉన్నాయి. ఆ రిట్స్ జారీ చేసే హక్కు ప్రస్తుతానికి సుప్రీంకోర్టు ఆర్టికల్ 32 ప్రకారం సుప్రీంకోర్టుకి, ఆర్టికల్ 226 ప్రకారం హైకోర్టుకి ఈ రిట్స్ జారీ చేసే హక్కు ఉంది. ఆ 2 కోర్ట్స్ తప్ప వేరే కోర్ట్ రిట్స్ జారీ చేయకూడదు. కానీ అలాంటి కోర్ట్స్ కూడా అదర్ దెన్ హైకోర్ట్ అండ్ సుప్రీం కోర్ట్ ఈ రిట్స్ జారీ చేసే అధికారాన్ని వేరే కోర్టుకి కూడా ఇవ్వబడుతుంది. అది పార్లమెంట్ ఆ చట్టం తీసుకొస్తే. సో పార్లమెంట్ హ్యాస్ ద పవర్ టు ఇష్యూ రిట్స్, టు empower other court to issue writs other than high court and supreme court. So అలాంటిది కూడా ఆర్టికల్ 35 చెప్తుంది. ఆర్టికల్ 35 empowers the parliament to give power to issue writs for other courts also. So many things, for example article 33 ఏం చెప్తుంది, ప్రాథమిక హక్కులు అనేది ఆర్మ్డ్ ఫోర్సెస్కి అందరిలాగా వర్తించదు. కొన్ని నియంత్రణ తీసుకురావచ్చు పార్లమెంట్ ఆర్మ్డ్ ఫోర్సెస్ యొక్క ప్రాథమిక హక్కుల పైన. అలానే ఆర్టికల్ 34 ఎక్కడైతే సైనిక చట్టం అమల్లో ఉందో అక్కడ ఆ ప్రాంతంలో నివసించే వారికి కానీ అక్కడ ఉన్న ఆర్మ్ ఫోర్సెస్ వారికి కానీ ఆ ప్రాథమిక హక్కులు అనేది అప్లికబుల్ అవ్వదు. సో అలాంటి కొన్ని చట్టాలు తీసుకొచ్చే హక్కు పూర్తిగా పార్లమెంట్ దగ్గర ఉంది. అదే ఆర్టికల్ 35. We have said that Article 35 gives the Parliament a power to bring certain law and also bring the nature or the type of punishment. So this is Article 35. So we have many things like this where Parliament will decide on what kind of punishment to be made for breaching certain fundamental rights. When we say Article 17, it talks about untouchability. If anyone practices untouchability, Parliament would obviously come with a very stringent law and also punishment so that the fundamental right is been restored or the social evil like untouchability is not practiced. We also have a traffic in human beings. This we have discussed in Article 23. Here human beings involves men, women and also children. So if there is any action which is against the human rights or natural justice, then such actions will be prosecuted or such persons will be punished with stringent laws. సో ట్రాఫిక్లో హ్యూమన్ ట్రాఫిక్స్లో మనం చాలా చూసాము. ఇది రైట్ అగెయిన్స్ట్ ఎక్స్ప్లాయిటేషన్లో చదువుతాం మనము. సో ట్రాఫికింగ్లో ఏమైనా ఉండొచ్చు, ప్రాస్టిట్యూషన్ కానీ, బేగర్ సిస్టమ్, జోగిని సిస్టమ్, దేవదాసి సిస్టమ్, ఇలాంటివి చాలా మనం చూస్తాము. సో అలాంటి దానికి చాలా స్ట్రింజెంట్ పనిష్మెంట్స్ ఉంటాయి. పార్లమెంట్ దాన్ని ఆ చట్టాలని తీసుకొస్తుంది. సో ఫోర్స్ లేబర్ ఆర్ బాండెడ్ లేబర్, ఆల్ దిస్ ఆర్ ద థింగ్స్ where the Parliament has the power to bring law and also give the nature of the punishment, to decide on the nature of the punishment. One thing we have regarding Article 35A, when we say Article 35, it has given some special provisions. Article 370 gives certain special provisions for certain section of the people. For example, in Telangana we have Article 370D where the Parliament has given special provisions for the in case of employment. The same way in Jammu Kashmir we had this. So special powers vested in President regarding Article 370. So what is Article 368 again? Article 368 is where the President has the power, or the Constitution, the Parliament has the power to amend certain provisions of the Constitution. Criticisms of fundamental rights. So on what basis we have criticized fundamental rights? These are the basic things we have to know. So just to brief this, we have excessive limitations on fundamental rights. దీనినే మనము మితిమీరిన పరిమితులు అంటాము. ఒక చేతితో ఫండమెంటల్ రైట్స్ మనకు ఇచ్చినట్టే ఇచ్చి ఇంకో చేతితో బ్యాక్ తీసుకుంటారు. సో చాలా వరకు మనం చూస్తాము. ఫర్ ఎగ్జాంపుల్ ఆర్టికల్ 19 క్లాజ్ 2లో మనకి కొన్ని గ్రౌండ్స్ విధించారు. ఏ గ్రౌండ్స్ మీద అయితే ఫండమెంటల్ రైట్స్ని పార్లమెంట్ లిమిట్ చేస్తుందో, సో మనం చూసుకుంటే సావర్నిటీ అండ్ ఇంటిగ్రిటీ ఆఫ్ ద స్టేట్, సెక్యూరిటీ ఆఫ్ ద స్టేట్, డిఫేమేషన్, కంటెంప్ట్ ఆఫ్ కోర్ట్, ఇన్సైట్మెంట్ ఆఫ్ అఫెన్సెస్, ఇలాంటివి కొన్ని గ్రౌండ్స్ మీద పార్లమెంట్ లిమిట్ చేయొచ్చు, ఫండమెంటల్ రైట్స్ని నియంత్రించవచ్చు. సో ఇలా మనం ఒక ఆర్టికలే కాదు, ప్రతి ఆర్టికల్లో మనకి కొన్ని లిమిటేషన్స్ ఉంటాయి ఫండమెంటల్ రైట్స్ మీద. సో ఎక్సెసివ్ లిమిటేషన్స్ రైట్ ఫ్రమ్ ఆర్టికల్ 14 to ఆర్టికల్ 35. ఇన్ ఎవ్రీ ఆర్టికల్ దేర్ ఆర్ సర్టెన్ లిమిటేషన్స్ ఆన్ ద గ్రౌండ్ ద పార్లమెంట్ క్యాన్ restrict the enjoyment of fundamental rights to all the citizens. So we have excessive limitations. All these things we will be dealing in detail. So no social and economic rights. మనకి మొత్తం ఫండమెంటల్ రైట్స్లో చాలా వరకు సోషల్ రైట్స్ కానీ ఎకనామిక్ రైట్స్ కానీ ఎక్కువ శాతం కనిపించదు. చాలా వరకు పొలిటికల్ రైట్స్ మాత్రమే మనకి కనిపిస్తుంది. సో నో సోషల్ అండ్ ఎకనామిక్ రైట్స్. వీ హ్యావ్ మోస్ట్ ఆఫ్ ద రైట్స్ ఆర్ పొలిటికల్ ఇన్ నేచర్. సో నో క్లారిటీ హియర్. It is clear that the words in the fundamental rights do not contain a clear meaning. The words are ambiguous. So interpretation would become difficult. High Court or Supreme Court will face many challenges in interpreting certain words. So we can say that the words or the fundamental rights themselves are not clear. స్పష్టత లేకపోవడము, ఎక్కడ ఒక క్లియర్ మీనింగ్ అనేది కన్వే చేయట్లేదు. నో పర్మనెన్సీ. మనం చూస్తాము కొన్ని ఫండమెంటల్ రైట్స్ని సాక్రోసాంక్ట్ అని చెప్పము, అది టెంపరవరీగా ఉంటుంది. ఎవరైనా అంటే కొన్ని సందర్భాల్లో పార్లమెంట్ దాన్ని రిపీల్ చేసేయచ్చు. సో చాలా వరకు మనం రైట్ టు ప్రాపర్టీ చూసాము, ఇట్ గాట్ రిపీల్డ్. సో పర్మనెంట్ అనేది లేదు. అండ్ వీ ఆల్రెడీ డిస్కస్ దట్ fundamental rights are not sacrosanct, they are not permanent, they can be modified, they can be repealed, or they can be taken away by the authority of law. So this is also one of the critics that fundamental rights are not permanent. So this we have seen suspension during emergency. In times of emergency, fundamental rights could be suspended. So ఎప్పుడైనా కామన్ కండిషన్స్ కాకుండా ఒక అన్సర్టెన్ కండిషన్స్ ఉన్నప్పుడు, అబ్నార్మల్ కండిషన్స్ ప్రివేల్ అయినప్పుడు, లా అండ్ ఆర్డర్ బ్రేక్ అయినప్పుడు, లేదంటే మనము వేరే కంట్రీతో వార్లో ఉన్నప్పుడు, అలాంటి సందర్భాల్లో మన ఫండమెంటల్ రైట్స్ని సస్పెండ్ చేయడం జరుగుతుంది. సో అత్యవసర సమయంలో సస్పెన్షన్కి గురి అవుతాయి ఫండమెంటల్ రైట్స్. అందుకే మనం చెప్తాము ఫండమెంటల్ రైట్స్ ఆర్ నాట్ పర్మనెంట్. సో దీస్ ఆర్ వెరీ ఎక్స్పెన్సివ్. If anyone has a complaint, like anyone's fundamental right got violated, then such person, if he needs to go to Supreme Court or to go to High Court, so that is a very expensive process. He should hire an advocate, and advocates generally they charge a lot of money. So to ensure that our fundamental rights are protected, which are guaranteed by the Constitution, but to ensure their protection, it is very expensive. So going to court, moving the court, and it takes a lot of time in the court. So ఇది చాలా ఖరీదైన పని, very expensive. We have seen many people are still lodged in so they've been arrested, detained, lodged in cells, jails, because they don't have money to hire an advocate. So it's emergency. In emergency situations, we can see that many people got detained, and for their bail, to get a bail, they need an advocate, a lawyer who generally charges a lot of money. So we can say that this remedy is not viable for poor section of the people. They cannot afford these legal things. So we can say that it's very expensive. Preventive detention is one such thing where we cannot ensure that our fundamental rights being protected. So preventive detention is a clause in fundamental rights only. We have said that it's a process where any person could be detained before he indulges in any crime. So if any person on suspicious basis, the police can arrest and detain a person. So obviously this kind of clause is against fundamental rights. It is against Article 22, where we say it is unlawful to detain any person without any trial. So this is an exception, but it is definitely a limitation on fundamental rights. So on this basis, fundamental rights has been criticized. So no consistent philosophy. This is one thing which is been criticized by the critics. We say that in entire fundamental rights, we need to follow certain philosophy in our constitution also. But fundamental rights has no single clear-cut philosophy. In some areas we talk about socialism, in some areas we talk about humanism, capitalism, all. So definitely there is no single philosophy which is leading the entire fundamental rights. So again, this is a chapter of confusion which led many critics to criticize the fundamental rights. Going into detail, so when we say excessive limitation, first thing is fundamental rights are justiciable. They are justiciable in the sense any person who gets violated of their fundamental rights can move Supreme Court or High Court. So one thing is we know every citizen is aware that if any action of the state or any public authority which takes away or abridges the fundamental rights, then such action could be made invalid by Supreme Court or High Court. That is one clear thing. But within the fundamental rights, we have seen many such clauses which they themselves put restriction on the fundamental rights and on their applicability. So there are many limitations on the applicability of fundamental rights. We say the state has clear thing that there should be a fundamental right, every person will enjoy fundamental right, but on certain basis they are curtailed. So in all the fundamental rights, right from Article 14 to Article 35, all fundamental rights are subject to some sort of restrictions placed by the state. On the same thing, there are many cases which are in Supreme Court, and Supreme Court has given many judgments. There was always a continuous type of struggle or war between Parliament and Supreme Court. Parliament will come with certain law which obviously takes away fundamental right of a common people or a citizen. Then they will approach Supreme Court or High Court. Then what happens? The Parliament again amends the fundamental right and adds some clause or some provisions in that. So the state's action in general has taken away the liberty or the freedom to enjoy the fundamental rights. We know right to property is one such fundamental right, where on that particular clause there were a lot of cases in Supreme Court. So there are many restrictions, there are innumerable exceptions, qualifications and explanations regarding right, that is fundamental right. So we can say that Constitution has granted fundamental right, but it has more exceptions in fundamental rights. It has more exceptions regarding reservations, regarding many exceptions which are applicable to some person and which are not applicable to some other persons. So there are many exceptions. For example, in Article 31A, 31B and 31C, these three articles have a lot of exemptions. That is, when a state acquires or takes away the land, those people who have lost their land cannot move Supreme Court because it is based on the reason is agricultural reforms. Or when we say that right to property, no one should go to court regarding right to property. So we have repealed that right to property and we have made only as a legal right, that is an ordinary right under Article 300A. We have many such exceptions in all the fundamental rights. That is the reason why critics have called this as excessive restrictions on fundamental rights. They have criticized fundamental rights on the basis of excessive restrictions, exceptions, explanations, etc. So Jasprit Rai Kapoor has said, it is not a list on fundamental rights, but a list on exceptions on it. So the extent of fundamental rights we generally see, there are many fundamental rights. At the same time, every fundamental right have its own exceptions, its own explanations and its own restrictions. So all these things have made fundamental rights very confusing. No social and economic rights. See, when we read fundamental rights right from Article 14 to 35, we generally seldom see rights on social and economic rights. Most of the things are specially regarding political rights of the citizen. So one thing we need to understand is, unless there is a right for economy or right for social good things, we cannot achieve political rights. If any citizen is not given economic right to prosper, what will he do with the political rights? That is the reason now in our democracy we are seeing a lot of inequalities. people have political right in the terms of voting. Like we have universal adult franchise. Every person who has achieved 18 years of age, who have crossed 18 years of age, can vote. But what if they do not have economic independency? What they do not have the way to earn? So they generally are misguided by these political parties. So every citizen, every common people, every common person should have both social and economic rights. So in this fundamental rights, we generally see most of the rights are social, that is political rights, but not socio-economic rights. So what about that social economic rights? Right to social security. Social security is like we need to have, any person need to have three common things like shelter, food and work. So very rarely we see that fundamental rights has provided that with us. So right to work, right to employment, right to rest and leisure. Of course, these are mentioned in directive principles of state policy, but in fundamental rights we have given more sort of political rights. That is, on that basis critics have criticized fundamental rights. That is, fundamental rights what we have in our constitution in part 3 are giving more importance to political rights but ignoring social and economic rights. No clarity, స్పష్టత లేకపోవడం. In our fundamental rights, many words are there which are not clearly defined. There are many words or the many statements which do not carry clear meaning. For example, we have public order. Public order, it is mentioned in Article 19 Clause 2. On the basis of disturbance or to public order, state could impose restrictions on right to freedom. So then what is public order? Many people can interpret public order in their own words. So we do not have a clear definition of public order. Even the word minorities has not been explained in details. We have a confusion with minorities. We may say religious minorities, linguistic minorities, but there is no clear explanation of the word minorities. Reasonable restrictions. Reasonable restriction is also a word where the parliament will restrict on the enjoyment of fundamental rights. It says we have reasonable restrictions. So what is reasonable? Reasonable is a relative term, and to find that the restriction placed on the fundamental right is reasonable or not reasonable, that is again the court should interfere. The court should decide that the restrictions imposed are whether reasonable or not reasonable. But neither anywhere it has been explained that what reasonable is. Reasonable అనే వర్డ్ని ఎక్కడ ఒక స్పష్టంగా ఎక్స్ప్లెయిన్ చేయలేదు. సో దానివల్ల ఏమవుతుందంటే కన్ఫ్యూజన్ క్రియేట్ అవుతుంది. దేర్ ఇస్ ఎ లాట్ ఆఫ్ అంబిగ్విటీ. అది హైకోర్టు కానివ్వండి, సుప్రీంకోర్టు కానివ్వండి, ఆ వర్డ్ని ఇంటర్ప్రిట్ చేయడంలో ఒక అంబిగస్ నేచర్ ఉంటుంది, ఒక కన్ఫ్యూజన్ క్రియేట్ అయిపోతుంది. సో ఇలాంటి వర్డ్స్కి ఎక్కడ క్లియర్గా ఎక్స్ప్లెనేషన్స్ ఇవ్వలేదు. అందుకే మనం చెప్తాము క్లారిటీ లేదు, ఒక స్పష్టత లేకపోవడం వల్ల ఈ విధంగా క్రిటిక్స్ ఫండమెంటల్ రైట్స్ని క్రిటిసైజ్ చేశారు. సో పబ్లిక్ ఇంట్రెస్ట్ కూడా అలానే సింపుల్, అది అంబ్రెల్లా వర్డ్, అది పబ్లిక్ ఇంట్రెస్ట్ అని. ఎక్కడ కూడా పబ్లిక్ ఇంట్రెస్ట్ అంటే ఏ పబ్లిక్కి ఏ ఇంట్రెస్ట్ అనేది ఎక్కడ చెప్పలేదు. సో దీని పరంగా మనకు అది ఇంటర్ప్రెట్ చేయడం అనేది చాలా కష్టమైన పని. ఓన్లీ లాయర్స్ ఆర్ ఏబుల్ టు అండర్స్టాండ్ దీస్ వర్డ్స్. దట్ ఈస్ ద రీజన్ వై సర్ ఐవర్ జెన్నింగ్స్ హ్యాస్ కాల్డ్ దిస్ ద కాన్స్టిట్యూషన్ ఆఫ్ ఇండియా ఈజ్ అ పారడైజ్ ఆఫ్ లాయర్స్. Only lawyers are able to understand. Even they are also find difficulty to understand the words mentioned in the constitution, because the constitution has written by legal luminaries who were barristers, who studied in London. So it is very difficult at our level to understand the constitution and the words in that. So we can criticize the fundamental rights on lack of clarity, clarity, and it is ambiguous. That is, we can interpret those words in different way. So no permanency, as we say, the fundamental rights are not permanent, they are not sacrosanct. So in times of emergency or in any other times, these fundamental rights can be abrogated, can be repealed, can be modified. So they are not permanent. The parliament can curtail or abolish them. Example, abolition of right to property. Right to property has been abolished. It was under Article 31. It was abolished. It was also under Article 19 clause F. So the right to property was abolished. So we can say that fundamental rights are not permanent. So these tools, because they are not permanent, because parliament has the power to take away fundamental rights at their will and wish. So that becomes, a play tools in the hands of politicians. Politicians, when they are in majority in the parliament, they might take away the fundamental rights. But the judicial review, as we say, the basic structure is one thing which acts as a limitation on the arbitrary power of the parliament. Otherwise, we can say that fundamental rights are not permanent. So these can be suspended during emergency. అత్యవసర సమయాల్లో వీటిని సస్పెన్షన్ చేయవచ్చు. సో సస్పెన్షన్ ఆఫ్ ద ఎన్ఫోర్స్మెంట్. సో we have fundamental rights, but we cannot enforce them. No one whose fundamental rights has been taken away could go to court and ask for their enforcement, though, because their enforcement has been suspended at times of national emergency. So we can say that many people are still lodged in the jail because they have been punished. They are led to punish and they cannot move the court. So they are under jeopardy. That is, they are facing punishment. So what critics say that, as per the critics, fundamental rights should be enjoyed in all times, be it normal or abnormal. So fundamental rights are fundamental things for the growth of individual and also for the society. So what critics says that, or experts of the constitution say that, in emergency times also fundamental rights should be enjoyed by the citizen. Obviously, because in normal circumstances there is no harm for fundamental rights, but in times of emergency only many of the fundamental rights will be taken away by the state. So what critics say that in times of emergency only there is a need to have protection for their fundamental rights. So this is very expensive, chala kharidainadi. When we say fundamental rights are very difficult to understand, and to make sure that our fundamental rights are protected, and if at any time our fundamental rights has been taken away, we should move the court. Now moving the court, going to the Supreme Court or High Court is not a simple thing. Our Supreme Court is at Delhi. So people living in down south cannot go to Delhi, stay there, hire an advocate, take an advocate and file petition in the court. So it's very expensive process. So to protect our own fundamental rights, you need to have lot of money. So it's very expensive. You need to have lot of time, patience and all. You have to fight with someone who is more powerful than you, more mightier than you. So definitely it's an expensive process. So judicial process is too much expensive, as at one hand Supreme Court says that yes, we take your petitions, but to file the petition we need a lot of money. So critics say that rights benefits the rich sections of the society, but poor man cannot afford the expensive judicial process. So rich man obviously he can afford. So here the poor people have disadvantage when they want to go to court for the protection of their own fundamental rights. So it's a thing when we say that Article 22 says that illegal detention is not right. If any person is detained, then he should be produced before the magistrate or court within 24 hours. And again we say that there is a other class, preventive detention. What preventive detention? In this case any person can be arrested and detained, and he could be detained for at least 3 months. More than 3 months they should have a advisory report. So advisory committee should extend that period, but for 3 months they can be detained. So it again violates Article 22. But what this says is preventive detention. It is a clause to to stop or to prevent any untoward activity or to secure law and order in future. But again, this is an arbitrary power, and it is also most misused provision in the constitution. It has an arbitrary power in the hands of the executive agency, who could easily detain any person on the suspicion basis. So arbitrary powers on the states and negates individual liberty, because here when we say Article 22, that is detention, preventive detention, it negates Article 21, right to life and personal liberty. So no democratic country in the world has preventive detention clause. That is, at times of normal conditions prevailing also, no democratic loving country or freedom loving country, democracy, have these kind of provisions. They have certain provisions, but that is in times of emergency. But in our constitution, even in normal times also, any person could be detained and held for many months. So this is a unique concept. The reason is we are preventing the untoward situations or any situations which causes or damages the national integrity or security of the state. So on that basis, many people have been detained. So we say that no consistent philosophy. See, every constitution has its own philosophy. We have borrowed many things from different parts of the constitutions of the world. So obviously, in our fundamental rights, no single philosophy has been followed. So critics have criticized that we do not follow a single philosophy. So Ivor Jennings said, fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. There is no consistent philosophy in our fundamental rights. We have socialist philosophy, we have Gandhian philosophy, and such other philosophies. So it is very difficult for Supreme Court and High Court to interpret fundamental rights, because we can see that the words mentioned in the Constitution has no clear meaning. They are ambiguous. They don't convey a clear meaning. So it would become difficult for the interpreting body, that is High Courts and Supreme Courts, would find it difficult to exactly interpret the words. So these are the things on the basis of which the fundamental rights has been criticized. It is not that fundamental rights are not advantageous. Yes, we know that fundamental rights are very much important for individuals' growth and also for the growth of the country. But we also have certain negative aspects when it comes to fundamental rights. That is, too much of restriction, too much of exceptions and explanations. And we also know that the words are not clearly mentioned, and whoever whose fundamental rights are being violated, and they should move the court, which is an expensive thing. So all this also a part which should be gradually taken away. So critics has been criticized on these aspects. So this is the gist of criticism of the fundamental rights. We are discussing Article 29 and 30 here in fundamental rights. Article 29 and 30, that is cultural and educational rights. We have already discussed right to equality from Article 14 to 18, right to freedom from Article 19 to 21, right against exploitation, Article 23 and Article 24, right to freedom of religion from Article 25 to Article 28. So this cultural and educational rights are provided in the fundamental rights. So when the constitution gave us right to freedom of religion, right to equality, right to freedom of expression, assembly, occupation, these all rights are also interlinked with cultural and educational rights. So in right to freedom, that is under Article 21A, we have universal compulsory education, that is free and compulsory education for all the children who are from 6 to 14 years of age. 6 to 14 years of age children are to be provided free and compulsory education, and it is the responsibility of the state. It's a fundamental right now. So this is again linked with our cultural and educational rights. So when we talk about cultural rights, what is this culture? As we know, every religion or every sect of the people have their own distinctive culture. They have their own identity, a unique language, unique script, maybe a unique dance, music, art, architecture, anything. So that could be their own culture, and that particular culture may be their identity. So every distinctive group have the right to protect and preserve their own culture. This is what Article Culture and Educational Rights under 29 says. So let's get into the Article 29. Protection of interest of minorities. So when we say protection of interest, what interest we need to protect? In terms of language, in terms of script, in terms of their own culture, their belief, their faith, all should be protected. So protection of interest of minorities, it's a broad word, protection of interest. It may also include educational interest, their belief, their system, doctrines, rituals, whatever they have. So in terms of script, language, art, so we call it as a culture. So culture need to be protected under Article 29. So to protect, in the journey to protect their culture, they can establish and administer educational institutions, because educational institutions are the places where their culture is revived. There will be a lot of debate, discussion to further improve or develop such script, language, or art, dance, etc. Educational institutions provide for progress and development of their people who are from that particular religion. So educational institutions are modern temples where one's culture is protected, preserved, and progressed. So this Article 29 and 30 are intended to protect the interest of minorities. Here we say, when we say minorities under Article 29, we also mean them as linguistic minorities. So what Article 29 says? Under Article 29 Clause 1, any section of the citizens residing in any territory, in any area, they have all the rights to preserve their language, their script, their culture. That is, they have the right to conserve the language, distinct language, culture of its own. So no one should impose restrictions, or no one should interfere in others' culture. That is prohibited. So if a section of people or a group of people who have their own identity in the form of language should not be compelled to take other language or forcefully compelled to speak in other language, because that particular language is the identity of that particular section. So when we say minorities, here there may be a linguistic minority under a majority religion. In Hindu also, in Hindu religion, there may be many linguistic minority people who in this process of development may be left behind. So our constitution ensures that such minority people should be given right to preserve and protect their distinctive identity. So this Article 29, it is not only for minorities as such. As this terminology, what we say minorities, it's not about religious minorities only. It is also about linguistic minorities. So Article 29 is not completely dedicated to religious minorities. This article, minorities here means linguistic minorities and also religious minorities. So in this we have two provisions. One is protects the right of a group, because when we say language, culture, art and all, it is a matter of a group, a community, a sect or a group of followers. So this article protects the interest of the group. And when we say Article 25, this article protects individual interest. That is what Article 25 says: right to freedom of conscience, right to, we have all the freedom to profess, practice and propagate any religion. So it is individual right. As an individual, that person can listen to his inner voice, he can take any religion, or if he is following some religion, due to many reasons he could convert to other religion. He may not be also part of any religion. That is individual interest. That Article 25 focuses on individual. Article 29 focuses on a community, a group, where we say protection of culture. The culture develops when there is a community, there is a group, and a group has the responsibility to protect their distinctive or unique culture, which is under threat maybe. So protect of rights of a group of people. And this provision also says that guarantees the right of a citizen. So individually also, no person shall be compelled or forced to not use their identity or to not follow their culture. So every community has their distinctive culture, and no one or no person shall be compelled to not follow their culture. So what types of minorities we have? This article, that is Article 29, says that we have linguistic minorities and religious minorities. Here when we say linguistic minorities, these minority people may be in majority religion. So in a majority religion, that is when we say Hinduism, and Hinduism also has Sikhism, Jainism and Buddhism. So all three sects are also included in Hinduism. So in Hinduism, we may also have a linguistic minorities, that is very small group of people who speak in that language. Generally when we say Hinduism, there are many languages, but there may be very small group of people who maybe do not have a script but speak some distinctive language, and Constitution has given the right to protect their own language, own culture. And obviously we have religious minorities. For example, in India, Jainism, Buddhism, Sikhism, Christianity, Muslim, Islamism. So these are religious minorities, and the state has given them the right to protect their language, their script, their culture, and also given the right to establish their educational institutions for protection of their culture and all. So not necessarily this article, that is Article 29, it's not necessarily restricted for minorities alone. When we say section of citizens, it may also include minorities as well as majority. In majority also, there are a section of people who are minor. Every minor people in this majority will not speak all the languages, like major languages like Hindi, Bangla, Tamil, Telugu and all. So there may be some distinct language which the majority of people also speaks. So this article is unqualified. When we say wide and unqualified, this has to be protected. So when we say unqualified, it is the government can interfere in such matters. It confers a special right not only to the minority but to the majority for admission in the state maintained educational institutions. So this article also gives right to the religious denominations or religious people to establish their own educational institutions. We have institutions for Christianity, for Muslims, for Hindus, etc. There are many educational institutions. As we say, a congregation like a Christianity, there are many Christian colleges, Christian schools who impart the education for the upliftment of Christian people, or they would spread the Christianity. That is Article 29. When we say Article 30, this is purely about minorities. This article is exclusive about minorities, and this is regarding the establishment of educational institutions. So Article 30 says that the state shall take steps and it should make an opportunity, give an opportunity to the people of minorities to establish their own educational institutions. So the state will not stop or curtail the freedom to establish minority educational institutions. This thing, compulsory acquisition of any property. So earlier, before repealing the right to property, we had property under the name of educational institutions. But after repealing the right to property under Article 19 Clause 1F, when we have repealed this under Article 31, now we have given a legal right to property, that is under Article 300. Actually it was a fundamental right, then we made it as a only legal right, and the government has taken many lands or acquisition of property, but the government has compensated for it. There should be an equal amount of compensation for those educational institutions when there is a taking away or acquisition of the property. So this is done by 44th Constitutional Amendment Act. And the state shall not discriminate in granting aid. This means, as we have multi-religions in our country, the state should give equal importance to all the religions. When it is spending some amount from the government budget, it should spend in a proportion to the population. Any particular religion should not be given importance or priority over other religions. This is again a concept of unique secularism what we follow in our India. State does not have any religion, but again state should not discriminate any religion at the cost of other. So all religions should be treated equally. Here when we say spending of budget or granting aid, the state shall not discriminate any religion. But here when we have minorities, here we have a positive kind of discrimination. here we are not against the reverse discrimination. When we say we are giving importance to the minorities, because we know the state should give a positive lift to minorities so that the fruits of development is equally distributed, or otherwise if the state does not provide grants to such minorities, they may be left back. Again, we can say this is contradicting Article 14, or there is no equality. But here, because minorities have their own persisting problems, they need to be protected by active involvement from the state. I would say that the state should not discriminate, but there should be a positive approach to bring them at par with the majority. That is where we could say that we are secular and we are striving for equality. So here discrimination is positive. This is also like providing reservation for underprivileged sections like SCs, STs and economically backward class, and also economically backward in other caste, upper caste people also. So Article 30 grants rights to minorities in establishing educational institutions. So what kind of educational institutions are there which seek recognition as well as aid? So the state will give recognition as well as aid, that is financial aid in terms of grants, in terms of budget, finance and all. Seek only recognition, not aid. There are many educational institutions which seek only recognition from the state. They will arrange their grant from other sources. There may be sources from other countries in the name of aid or funds. They may make their own corpus. They may make their own corpus from collection of money in terms of fees extra. And few institutions are there which seek neither recognition nor aid from the state. So these institutions will have an autonomous body which do not seek recognition and also finance or grant from the state. So these are the three types of educational institutions. So we have few judgments regarding Supreme Court on this. In case of Malankara Syrian Catholic College case, it's a case of Kerala regarding two orthodox sects of Christianity. They have fought over the property of the church, and it's still a big issue. So minority educational institutions have to choose its own governing body. Here this case can be contradictory to equal opportunity in appointment. So in educational institutions, especially for minorities, that minority governing body or the group of directors could choose anyone, maybe teaching or non-teaching staff or any person who is employed in such educational institutions. So they have all the right to choose anyone for the post. Appointment of teacher and non-teaching staffs. They can also show some privilege to admit certain students who are from that community. So the government only interferes when there is a threat to the standards or qualification of any staff. If under UGC guidelines, that is University Grant Commission guidelines, the institutions, educational institutions, be it college, school or university, they have to follow certain standards by the state, given by the state. So that might be eligibility or the educational standards or the standard in the syllabus. If it is not following the instructions or the standards prescribed by the government, this government can interfere and it could regulate such activities, regulations to prevent exploitation of employees or students. So in general, the government do not interfere in the matters of minority educational institutions. But obviously when there is a threat or when the standard is not to the level, the government will interfere and regulate the activities. So at a glance, we just see that cultural and educational rights, Article 2930. Article 29 says protection of interest of minorities. Here, minorities is not only minorities, but I say linguistic and religious minorities. So here both minorities as well as majorities are included. In majorities also we may find linguistic minorities. So this is protection of interest. It may be in terms of language, script, culture. When we say Article 30, this article gives right to establish their own educational institutions. And not only establishment, they could administer, they could maintain, they could run such institutions under the law of land. So thanks for watching my video. This is regarding fundamental rights, that is cultural and educational rights under Article 29 and 30. In fundamental rights, a very important article, that is Article 32. Article 32 is called the constitutional remedies. We have remedies in this article. So what is much important about this article is this article, that is Article 32, guarantees the fundamental rights. If any state action is against the fundamental rights, or the state action, if the action of the state or any such action violates fundamental rights, an aggrieved person can reach court. So the person who has got violated his fundamental rights can approach court under this article, that is Article 32. That is why we call this article as fundamental to all fundamental rights. There was a lot of debate in Constituent Assembly on this article, because when we give fundamental rights, when all the citizens have fundamental rights, it is also should make sure that all these fundamental rights are protected by the judiciary. So when we say we have fundamental rights and that are enforceable in court, we understand that any such fundamental rights, if gets violated, could be rectified by the court, or such action of the state should be declared null and void. So fundamental rights under Article 32. So we are discussing right to constitutional remedies. So we also have a right for the remedies. So the Constitution has given us the right to constitutional remedies. So here Article 32 gives power to Supreme Court to issue certain writs to various organizations, public authorities or private persons to make sure that the fundamental rights are restored. Any aggrieved person can approach Supreme Court under original jurisdiction and also various high courts for their restoration of fundamental rights. So Dr. B.R. Ambedkar said that this article, that is Article 32, an article without which this constitution would be nullity. So without Article 32, whatever fundamental rights we have or whatever provisions we have been provided by the Constitution would be a nullity. Such a large significance has been attached to Article 32. This article is heart and soul of the Constitution. So very important article. ఈ ఆర్టికల్ మన మొత్తం కాన్స్టిట్యూషన్లో ఒక ఆత్మ, ఒక హృదయం లాంటిది. సో చాలా ఇంపార్టెంట్ ఈ ఆర్టికల్ 32 అనేది. మనము ఏ ఫండమెంటల్ రైట్స్ అయినా ఒకవేళ వైలేట్ అవుతే ఈ ఆర్టికల్ ప్రకారము మనం సుప్రీం కోర్ట్ కానీ లేదంటే ఆర్టికల్ 226 ద్వారా హైకోర్ట్స్కి కానీ అప్రోచ్ అవ్వచ్చు. సో ఆర్టికల్ 32 గివ్స్ అస్ రైట్ టు కాన్స్టిట్యూషనల్ రెమెడీస్. దట్ ఈస్ ద రీజన్ వై we call it as a heart and soul of the constitution. So what are the provisions we have under this article? Importantly, we need to know. Importantly, we have 4 provisions. One, how we can approach Supreme Court or various high courts. Once we approach court, what are the tools with the court with which the court could restore the fundamental rights? So right to move the Supreme Court by appropriate proceedings for the enforcement of fundamental rights. So under Article 32, we can move Supreme Court for appropriate proceedings. So whenever we feel that our fundamental rights has been encroached, we can directly move Supreme Court under Article 32, and that particular court will issue notices or issue writs to those agencies, be it state, a department or any such agency, so that it could enforce the fundamental rights by declaring the state's action as null and void. So what are the tools we have? What are the tools the Supreme Court or various high courts have to restore or to enforce the fundamental rights? So we have writs. Writs are the tools used to enforce fundamental rights. We can call writs as a tool which is having with Supreme Court or High Court to ensure that whatever fundamental rights has been encroached or violated need to be enforced. So writ, we have brought this from English, that is England. We call them as prerogative writs. So these are the prerogative writs or fountain of rights. So we have these writs: habeas corpus, mandamus, prohibition, certiorari and quo warranto. These are the types of writs we have with Supreme Court and High Courts to enforce the fundamental rights. So these are the Latin names. We will be going in detail. So other provision of the Constitution. It is not only the Supreme Court and High Court which could issue writs, but Parliament has a sovereign authority. Parliament has the superpower so that it could ensure or it could empower other courts also to issue these writs or directions. Now, up till now, we have only Supreme Court and other high courts. Those are empowered to issue writs, but the Parliament has the power. It may be a question in competitive examinations: who is a designate authority or who is a supreme authority to empower other courts to issue writs? It is not Supreme Court, it is not President, it is not state assemblies, it is Parliament that could empower other courts. When we say other courts, it is excluding Supreme Court and High Courts, because the power to issue writs are already given under the Constitution by Article 32 for Supreme Court and by Article 226 for High Courts. So we already have that Supreme Court could issue writs, High Court could issue writs, but Parliament can empower other courts also. When we say other courts, other than Supreme Court and High Courts, be it district courts, be it metropolitan courts or such other courts, Now they do not have power to issue writs, but Parliament can empower such courts to issue writs. ఇప్పుడు ఉన్న పరిస్థితిలో ప్రస్తుతానికి సుప్రీం కోర్ట్ మరియు హైకోర్ట్స్కి మాత్రమే ఈ రిట్స్ ఇష్యూ చేసే పవర్ ఉంది. కానీ పార్లమెంట్ వేరే ఇతర కోర్ట్స్కి పవర్ ఇవ్వవచ్చు. సో అదర్ కోర్ట్స్ కెన్ ఆల్సో బి ఎంపవర్డ్ టు ఇష్యూ సచ్ రిట్స్. So we have already conferred on High Court under Article 226. This is mentioned in the Constitution. One more provision regarding Article 32 is the Constitution says that under emergency conditions, that is under national emergency, President can suspend to the right to move any court. So this is an exception. President can suspend the right to move court for the enforcement of fundamental rights when the state is under emergency, that is when national emergency is imposed under Article 352. President can order that no aggrieved person could move the court. That is an exception thing. So importance of writs. What are writ? It is a weapon in the hands of Supreme Court and various high courts to enforce fundamental rights. See why we need to enforce? Because when the state's action or any such policy, any such law which abridges, which takes away the fundamental right of any person, then that aggrieved person can move Supreme Court, and Supreme Court will quash or will declare such policies or such laws enacted by the Parliament or other legislative assemblies as void and null. పార్లమెంట్లో పాస్ అయ్యే ఏ చట్టమైనా ఏ పాలసీ అయినా ఒకవేళ ఒక పర్సన్ యొక్క ప్రాథమిక హక్కుల్ని హరించితే అది సుప్రీం కోర్టులో ఆ పిటిషన్ దాఖలు చేస్తే అలాంటి లా అది నల్ అని డిక్లేర్ చేయొచ్చు. సో అది ఇల్లీగల్, దట్ ఈజ్ అన్కాన్స్టిట్యూషనల్ అని డిక్లేర్ చేసే పవర్ సుప్రీం కోర్టుకి మరియు హైకోర్టుకి ఉంది. సో రిట్ అనేది ఒక వెపన్ సుప్రీం కోర్ట్ దగ్గర హైకోర్ట్ దగ్గర ఉంటుంది. సో దే ఇష్యూ దీస్ రిట్స్ టు దోస్ ఏజెన్సీస్ who have encroached into the fundamental rights from their policies, or because some policy of state government or central government which encroaches or which abridges the fundamental rights of a person or a citizen, then such policy or such law can be declared as unlawful. So fundamental rights and constitutional matters. So this power is given by the Constitution under Article 32 and under Article 226. So as I said, the system of writs are borrowed from English law. England, from UK we have borrowed this system of writs. We call them as prerogative writs. So these are held very important and hence they are called fountain of justice. Just imagine if we didn't had Article 32 as our fundamental right. All the rights enshrined in the Constitution in Part 3, that is fundamental rights, right from right to equality, right to freedom, right against exploitation, right for freedom of religion, right of educational institutions, all these rights could not be enforced. So when we say Part 3 of the Constitution, that is fundamental rights are enforceable. or they are justiciable. That means if any right is violated by the state, such law should be declared as unconstitutional by the constitution. So every citizen has the right to approach or to move Supreme Court if they feel that their rights has been breached. So that is the beauty of Article 32. When we say fundamental rights, the entire fundamental rights rests on Article 32. ఒక్కవేళ ఆర్టికల్ 32 లేకుండా ఉండి ఉంటే మనకు ఇచ్చిన ఈ ప్రాథమిక హక్కులు అన్నిటినీ అది వృధాగా ఉండేవి, బికాజ్ అవి ఎన్ఫోర్స్ చేయని పరిస్థితి. ఆర్టికల్ 32 గ్యారంటీస్ దట్ ఆల్ ద ఫండమెంటల్ రైట్స్ ఆర్ ఎన్ఫోర్స్డ్. సో this also becomes a deterrent to the parliament or to the state assemblies to bring such policies which are against the fundamental rights of a citizen. If any law framed by the parliament takes away the liberty of any citizen, so such law could be declared as unlawful under Article 32, because 32 guarantees the enforcement of fundamental rights. So writs are borrowed from English, as we said, and these are the fountain of justice. This upholds the preamble, because we have declared our preamble as the introduction to the constitution, and we have many things in the preamble, like we declare ourselves as sovereign, socialist, secular, democratic republic. We have justice, socio-economic, political justice, and all such things is only possible when the fundamental rights of a person are guaranteed by the highest law, that is highest authority. So we consider Supreme Court as the guardian of the constitution. Supreme Court ensures that the state should function according to the constitution. Constitution is the source of the power for all the three branches, be it legislature, executive or judiciary. But judiciary protects constitution. It is the guardian of the constitution, and any law which violates the constitutional thing, then Supreme Court or High Court will interfere. And Article 32 gives such power to the Supreme Court to use the weapon, to use the writs, to make sure that fundamental rights are enforced as mentioned in the Constitution. So, who will file writ petitions? Any aggrieved person or any person who thinks that his fundamental rights are got violated, or a person if thinks that his fundamental rights are breached by some state action, then such person could move the Supreme Court or High Courts. So we have various things. For example, in habeas corpus, anyone can file the writ petition in the court, not only that aggrieved person. Few other rights also there, we will be discussing that later. So writ petitions can be filed in High Court. This is under Article 226, and in Supreme Court under Article 32. So these writs can be issued by the concerned courts to such agencies or to such governments which pass the law or which has implemented the law. So there is a power of Supreme Court to admit the writ, to dispose it or give directions to the High Court. So we have a petition, special leave petition. Even this is also an important tool the judiciary has. So by this thing, the judiciary enforces or enables to protect the fundamental rights of the citizen. So these are the important kinds of writs we have. Habeas corpus. This is the Latin word habeas corpus. It means to bring the body. Corpus means body. So habeas corpus means to bring the body. We will get into the details. Mandamus. Mandamus means to command. Habeas corpus, to bring the body. Prohibition. Prohibition is we are prohibiting something. So prohibition means to prohibit, to forbid. Certiorari, to certify. Certiorari is to certify. Quo warranto, by what warrant? So we mainly have these 5 types of writs using in different circumstances for different uses. So for example, habeas corpus is a writ which could be issued to any public authority or private person. Same way, when we say prohibition, prohibition could be issued by a superior court to the inferior court. So here prohibition cannot be issued to other authorities. Even certiorari also such a writ which is issued by a higher judiciary to lower judiciary, that is a superior judiciary to inferior judiciary. Right to freedom of religion. We know right to freedom of religion is a fundamental right for every citizen. Not only the citizen, it is applicable for foreigners also. So right to freedom of religion is an important fundamental right. Reason being, we are very homogeneous, very heterogeneous, in fact, heterogeneous society. We have multi-religious in our country. We have a vast culture, very diverse culture. So unity and integrity is one of the bases which runs our country. So when we discuss preamble or when we discuss secularism, this right to freedom of religion, it strengthens the word secularism. So what is secularism? See, as we have multicultural, multi-religious society, we need to have a thing which unites everyone. So secularism is a concept in India where state will not promote any single religion. We do not have any state religion. For example, when we take our neighboring countries, for example, Pakistan, Bhutan, Bangladesh, Sri Lanka, Myanmar, these are few countries where there are state religion. For example, Pakistan is an Islamic country, Bangladesh is an Islamic country, Sri Lanka, it proposes Buddhism, and likewise. But in India, we do not have any state religion. That means India do not promote any single religion. In other words, it equally supports all the religions. So neither state is completely different or completely isolated from the religion, nor it adopts its own religion. So our concept of secularism is bit different from other Western countries. For example, in Western countries, when we say secularism, it is complete detachment of state and church. For example, in French Revolution, we say in French, we have in France, the word secularism denotes a complete separation of state and religion. But in India, as we have many religions followed, we have a lot of diversity. That is the reason why we have, separated our state from religion, but that doesn't mean that state has no responsibility or no right to interfere in the matters of religion. State has the responsibility to promote all the religions equally. So when we say right to freedom of religion, this fundamental right strengthens, supports the concept of secularism. So we have a difference in the concept of secularism when we compare to other Western countries. So what are the rights provided for us, for any citizen, in terms of freedom of religion? One thing we need to understand that religion, following religion, is a completely individual concept. It's a complete private concept. Anyone can follow any religion. Anyone can change their religion also in between. So the right to freedom provided in our constitution and also enshrined in fundamental rights gives every citizen to follow, to change their religion, to promote their own religion, to protect their religion, to establish or administer their educational institutions. So all these things have been provided in fundamental rights. If any action of the state violates these things, then a person could approach court, because these are fundamental rights and they are justiciable. So just broadly speaking, we have freedom of conscience and free profession, practice and propagation of religion. This is one. Freedom to manage religious affair, freedom for taxation, for promotion of a religion, and freedom of attending or not attending religious instructions. Now we have right to freedom of religion. We have 4 important rights given in freedom of religion, and this are from Article 25 to 28. When we say freedom of conscience and free profession, this comes under Article 25 of our Constitution. Freedom to manage religious affairs. We will be going in detail in these topics, but just to have an idea, freedom to manage religious affairs comes under Article 26. Freedom from paying taxes is under Article 27, and freedom to attend or not attending religious instruction comes under Article 28. So these 4 articles, 25, 26, 27, 28, gives a person or any individual or a group of persons their liberty, their freedom to profess, to propagate, to manage their own educational institutions, to collect fee, to use those fees as to develop their own institutions. All these things are being provided under Article 25 to 28. And that is why we say freedom of religion always strengthens the concept of secularism. And we in our nation, in our country, as we have multi-religious system, we have a need of this kind of rights under fundamental right to protect our sovereignty and integrity, to protect our security of the state, to protect our diversity and uniqueness of Indian culture. Getting into the detail, so freedom of conscience and free profession, practice and propagation of religion. So this is what we have clearly in our constitution under Article 25. So first let's discuss few meaning of the words. What do you mean by conscience? Conscience అంటే ఏంటి? ఒక మతాన్ని ఫాలో అవడానికి మన మనసులో ఉన్నది అది ఫాలో అవుతే అది కన్సైజ్ అవుతుంది. అంటే మనం ఇష్టం వచ్చినది ఏ మతాన్నైనా మనము ఫాలో అవ్వచ్చు. కన్సైన్స్ ఈజ్ నథింగ్ బట్ you have no, whatever you feel, how you connect with the God. That is what conscience is. You can relate yourself with God or any other creature in different ways. For example, when we say Mirabai, how she was connected to Lord Krishna. She herself thought that Lord Krishna is her husband. So that is her belief, that is her faith. So that is her conscience. So that conscience is given by our constitution. You have freedom, you have all the freedom to relate yourself with the God in any way as you desire, as you like. So that is the word of conscience, that is inner freedom. What we think in our heart, what our soul thinks, you could connect in whatever way you feel to the God. When we say religion, obviously we are talking about some superpower to which we are surrendered. So inner conscience is inner freedom. You have all the freedom, your soul, your heart, your mind. You could relate yourself to that God in whatever thing you believe in or you are liking. So you have all the freedom. So whatever you feel inside, you can also profess. Profess is you can come and talk to anyone regarding your inner conscience. మీరు ఒక ఆత్మలో అనుకుంది ప్రొఫెస్ చేయొచ్చు. మీరు ఏ రిలీజియన్ అయితే ఫాలో అవుదామో అనుకుంటున్నారో అది మీరు బహిరంగంగా చెప్పుకోవచ్చు. సో ఆ ఫ్రీడమ్ మనకి మన కాన్స్టిట్యూషన్ ప్రొవైడ్ చేస్తుంది. సో మనసులో అనుకోవడం ఒకటి మాత్రమే కాదు, మీరు ఏ మతానికి విశ్వసిస్తున్నారో, మీరు మిమ్మల్ని దేవుడితో ఎలా రిలేట్ చేసుకుంటున్నారో అది మీరు మనసులో మాత్రమే అనుకోకుండా దాన్ని బహిరంగంగా మనము చెప్పుకోవచ్చు. దట్ ఈజ్ యూ హ్యావ్ ఆల్ ద రైట్ టు ప్రొఫెస్. See, here professes, you are telling someone, another individual, maybe from your family, your friend, your parents or your community, whatever, you have all the freedom to express your feelings regarding some religion or God or creature or anything. So that is the right to profess. Here when I say God, there might be someone who may not believe in God. So that thing also you have all the right to express. When I say freedom of religion, it does not mean that every individual should follow some religion. Some may be atheist. Some may not believe in the system of God or religion. So some individual who follow some religion or do not follow some religion, they can express themselves, and state will not provide any restrictions on that unless we have a few, as I said, reasonable restrictions on the basis of morality, on the basis of public order, on the basis of general health. When I say public order, ప్రజాశాంతికి ఏదైనా భంగం కలిగినప్పుడు, లేదంటే నైతికతకి ఏదైనా ఇబ్బంది ఉన్నప్పుడు, లేదంటే ప్రజా ఆరోగ్యానికి ఏదైనా ఇబ్బంది కలిగినప్పుడు స్టేట్ అలాంటి యాక్ట్స్ మీద రిస్ట్రిక్షన్ తీసుకురావచ్చు. అది చిన్న ఎగ్జెంప్షన్స్ మనకి. అదర్వైజ్ స్టేట్ హ్యాస్ గివెన్ ఆల్ ద ఫ్రీడమ్ టు ఎక్స్ప్రెస్ యువర్ ఇన్నర్ ఫీలింగ్ రిగార్డింగ్ రిలీజియన్, టు ఫాలో ద రిలీజియన్ ఆర్ టు నాట్ ఫాలో ద రిలీజియన్ ఆల్సో. So that is right to profess. What it does says, religious beliefs and faith, what you profess, you openly express your feelings that I have belief in that system, I believe in that God, I have faith in that system, I have faith in that religion. So this is what you can express. That is right to profess. When I say right to practice, it is only not that you have inner feeling, your soul says that you have attached to the God or not to the God or not to any religion, or you have attached to some religion. It also means you are professing, like you are openly saying to the community that I follow this religion, That is okay, that is your professing. But in practice also, you could do anything. Like you could go to puja, you can you break coconuts. So the thing is, you can practice in any different way. So practicing is practically showing your respect towards your religion. We have many beliefs, we have rituals in, for example, Hindus, they have their own rituals. In Christianity, they have their own rituals. Muslims do have rituals. Buddhist, Jainism, Sikh, take any religion, they have their own style of rituals or performing prayers. So that you can practice as your religion says. So it is not only that you have a connection, inner connection with some religion or with some God, you also have a right to practice that. Practice is you practically, you connect with the God in various rituals. So you have all the right to practice. That is religious worship. You have your own style of worshipping. You may just go to the temple, or you may not go to church. You can just pray from home. Whatever it is, that is how you connect with your God, with your religion. No one would force you. Or you have all the right to practice in your family, in places, in any religious places. You can practice on your own. You have all the right. So that is religious worship, rituals, ceremonies. All these things are the practical things where we do, where we show that we are following these religions. So that is right to practice and right to propagate. When you have a faith in your religion, when you believe some system, when you believe that following this religion will definitely make yourself more powerful, or you feel better when you follow some religion, then there is nothing wrong that you preach that religion to someone, to your family, to your friends, to any organization. You can preach that. So you are propagating your religion. You are propagating, that is, you are telling your experiences, you are sharing your experiences to other people about your religion. So you have all the right to propagate about the religion what you are following. Here, right to propagation doesn't mean, we have few exceptions. You cannot convert people forcibly to some other religion. So you have all the rights to propagate your religion, to make understand other people the beauty of the religion you are following. But that doesn't mean that you force someone to convert from other religion to this religion. So we have an exception there. So right to propagate. These four things are important in Article 25. We have freedom of conscience. Conscience is what you think inside, what your soul says, how you relate yourself with that religion or with the God, with the goddess. Right to profess. You can speak openly. You can talk about your religion, your practices, your rituals and all. So you have the right to talk openly. No one will stop you. Right to practice. You could practice the rituals. Every religion has their own rituals, ceremonies, style of praying. So time of praying. We have holy months. We have festivals and whatnot. So all these things have to be performed. So you have all the right to perform the rituals mentioned in the religions, or it is a practice following from years together. And right to propagate. You can propagate your own religion. You can make people know about what religion you are following, what is the good things in your religion. So when we say right to freedom, it is not only religious beliefs but religious rituals. Rituals is performing something regarding that religion. You believe is inner thing, what you have in your soul, in your mind, in your heart. Rituals is when you perform something. For example, we perform puja. we perform puja, we go to the church and we offer prayers. So all these things are the rituals practiced in different religions. Rights are available, as we say, both for citizens or non-citizens. Even foreigners will enjoy these rights. So there are some restrictions where state could restrict our right to freedom of religion on the basis of, what are the basis? Public order. Public order. ప్రజాశాంతికి ఏదైనా భంగం జరిగితే స్టేట్ రిస్ట్రిక్ట్ చేయొచ్చు. మొరాలిటీ, ఎథిక్స్, నైతికత, దాని మీద ఏదైనా మీ యాక్షన్ వల్ల ఎవరికైనా ఇబ్బంది జరిగితే స్టేట్ రిస్ట్రిక్ట్ చేయొచ్చు ఈ ఫండమెంటల్ రైట్స్ని. హెల్త్, పబ్లిక్ హెల్త్ ఫర్ ఎగ్జాంపుల్ లౌడ్ స్పీకర్స్ పెట్టుకున్నాము టెంపుల్లో కానీ, మాస్క్లో కానీ, ఇంకెక్కడైనా కానీ, దానివల్ల నైట్లో డిస్టర్బ్ అవుతుంది, లేదంటే సౌండ్ పొల్యూషన్ పెరిగిపోతుంది, దానివల్ల కామన్ మ్యాన్కి డిస్టర్బ్ అవుతుంది అంటే స్టేట్ అనేది కొన్ని రిస్ట్రిక్షన్స్ పెట్టవచ్చు వాటి మీద. మనము చాలా ఎగ్జాంపుల్స్ చూస్తుంటాము. వినాయక చవితిని మనము నిమజ్జనం చేసేటప్పుడు కొన్ని లేక్స్ను దే లూజ్ దేర్ శాంక్టిటీ, పొల్యూషన్ అవుతుంది, వాటర్ పొల్యూషన్, వాటర్ బాడీస్ పాడవుతాయి. సో అలాంటప్పుడు గవర్నమెంట్ క్యాన్ రిస్ట్రిక్ట్ సచ్ యాక్ట్స్, బట్ ఆబ్వియస్లీ గవర్నమెంట్ విల్ provide with some alternative, not totally restricting on your fundamental rights, but it is also the duty of a common man to protect our environment, to protect our surroundings, because even it is not only the state, it is us. We need to take the responsibility to ensure that our surrounding is clean, our society is strong. You should not disturb any other sentiment. So if someone is getting disturbed by the act we do, so definitely we have a problem there. You are enjoying your rights, but you are forgetting that you also have a duty towards the society to not disturb others, people or other sentiments. So that is where we have few reasonable restrictions. So what state will do? State ekkada regulate chestundi manaki. So even we know that state has given all the rights to you. Even state will promote all religions equally by by giving aid, by giving money. So state can also regulate and restrict any economic or financial and political activity associated with religious practices. Otherwise there may be a problem. So state, as we earlier said, our style of secularism or the secularism we follow in our country is different from Western countries. In Western countries, secularism is total separation of state and religion. Though we follow a different style of secularism here, we are not totally separated. State says that India do not have any state religion, but that doesn't mean that India is not supporting religious beliefs. Our country sees all religion equally. It promotes every religion equally. So definitely state also have a responsibility. It also has the responsibility to ensure that this freedom should not bring disturbances in terms of chaos, in terms of communal violence, in terms of conversion, that is forced conversion and whatever. So state has the responsibility to restrict this freedom of religion in some or other way. So it could restrict regarding economic, when we say that funds are coming, so that funds may be misused by such religious denomination. So we have political activity, because religion is different, but on the name of the religion, few people could make some statements which may disturb the integrity of the state. So it can also regulate the functioning or political functioning of such religions. So we have all these religions, should we promote them? we promote the welfare of our own people, our religions, and in this we have that gradual reform in the society or in particular religion. There is always, it is because it's a dynamic entity, the state could initiate few steps to make reform or throw open Hindu religious institutions for a public character to all Hindus. When we say to all Hindus, we also should understand that here Hindus include Sikh, Hindus includes Buddhist, Hindus also includes Jains. So all Hindus, in this provision, the state could throw open its religious denominations or it could make reforms in Hinduism. Here we should not think that state is interfering in the religious matters. No, we have provided in our constitution that it is a biggest dynamic thing that there have to be some changes, there have to be some dynamism in that religion. So that is clearly mentioned in our constitution. So we have done with right to freedom, in that freedom of conscience, freedom to profess, to propagate all the religions. Next, coming to Article 26. This is a part of freedom of religion. In this, freedom to manage religious affairs. So as we earlier said, though we have freedom of religion, it is not only that you yourself believe in the God. Obviously, there will be a big society, big congregation in some religion. So gradually there will develop few trust, boards, temples, group of temples, society. So to manage such institutions, to manage such denominations, here when I say denominations, it is a group of similar believing people or a sect in religion. So denominations may be in the name of trust, temples, societies, etc. So under Article 26, state has given the right to establish and maintain institutions for religious and charitable purpose. మనకి కాన్స్టిట్యూషన్ ఆ రైట్ ఇచ్చింది. మనము ఒక రిలీజియన్ని బిలీవ్ చేస్తే ఆ రిలీజియన్కి సంబంధించి కొన్ని ఇన్స్టిట్యూషన్స్ గ్రో అవుతాయి. అది ఒక గ్రూప్ ఆఫ్ టెంపుల్స్ మేనేజ్ చేసే ఒక బోర్డు కానివ్వండి. ఫర్ ఎగ్జాంపుల్ టీటీడీ, తిరుమల తిరుపతి దేవస్థానం, అది ఒక రిలీజియస్ ఎస్టాబ్లిష్మెంట్. సో ఆ రిలీజియస్ ఎస్టాబ్లిష్మెంట్ కోసం మీరు ఏమైనా చేయొచ్చు. యూ కెన్ బై ప్రాపర్టీస్, you can use those income in the further development of that religion. అక్కడ నుంచి వస్తున్న ఆదాయాన్ని మరి అదే రిలీజియస్ డెవలప్మెంట్స్ కోసం యూజ్ చేయొచ్చు, లేదంటే చారిటబుల్ ట్రస్ట్ కోసం యూజ్ చేయొచ్చు. మనం చూస్తుంటాము టీటీడీ కానివ్వండి, శ్రీశైలం కానివ్వండి, ఎక్కడైనా యూ టేక్ అమృత్సర్ గోల్డెన్ టెంపుల్, యూ హ్యావ్ ఫ్రీ ఫుడ్ దేర్, యూ హ్యావ్ మెనీ అదర్ సర్వీసెస్. So to provide pilgrims or people to use their services, definitely the board could acquire property and use those property. So what I mean to say is you have all the right to establish, to maintain institutions for religious and charitable purposes. That is 26A. So once you started a society, once we have a good congregation, so your income, the income of that trust increases and you want to propagate that religion, so you need to establish more such institutions. For that you will manage, you have the right to manage own affairs in matters of religion. No state would interfere in this. That particular board or that particular committee will manage its own affairs when there is a registered society under some name. So that registered society can buy lands, can propagate its affairs, can appoint persons from that board. So government will not interfere into the matters of religion. So this is, you have the right to manage own affairs regarding religion. So as I said, right to own, acquire movable and immovable property. That is, if you have a religion, a congregation, a registered society, you have the right to buy buildings, construct temples, construct charitable houses, construct houses for the poor people, construct school for children. Like, you could do anything. You have that own registered independent society. That particular board has all the rights to use the money in the development, in the further development of that religion, and also for charitable purposes. When we say Shirdi is a big temple, we have a board there. They does many activities. Tirumala Tirupati Devasthanam, they does many activities. Even Golden Temple, they have many charitable things. You take any religion, Walk board, it is also a religious congregation. So walk board will also do many charitable activities. So every religion, every person in that particular religion have all the right to propagate their own religion and give better service to the people. So many religions which believe in God or any creatures have all the rights to establish their own religion. For example, when we say Ramakrishna Ashram, it's a big machine. It's a mission working for many charitable things. They provide free food, free shelter to many people. They distribute books. They also provide few courses. So all these things they are doing because Constitution has given them the right to own and manage their affairs. So they can manage, acquire movable and immovable property. And the property, how you use that property, that is also up to that board. We have a right to administer such property in accordance with the law. So there is a law of the land. Such property should not be misused, or as I said, should not be against public order, morality and health of people. So you should follow the law of the land, and within the limits set by the Constitution, you can enjoy the rights that particular board can purchase movable properties, immovable properties or any property and administer in the way they like. So that is right to administer property in accordance with the law. Hope it's a simple thing. Article 26, it is about establishing and administering institutions, religious institutions, that is denominations. Denominations are a sect, a group where you propagate, you promote, you progress your own religion. So that is one thing you can establish. You can manage your own affairs. You can have the rights to acquire movable and immovable property. You have the right to administer such property, but within the limits of the law. So as I said, this Article 26 are subjected to few restrictions, that is public order, morality, health. So these three are the grounds on which the state could impose restrictions. So religious denominations must satisfy three conditions. You need to understand what is denomination. Denomination ante, it's not demonstration, it's a denomination. Okay. Any group of people following a similar beliefs, thoughts, or they purchase something which is common to one, that is denomination, or we can say a sect in a religion. So regard as conducive to their spiritual well-being, any organization you register or you promote, that should be within the religion, that should promote the religion, should not disturb other religious sentiments. Common organization, there should be a common organization, that is under one umbrella organization. We may have different sub-organizations, but the trust should be a common, or there should be a common religion. It should be with a distinct name. Some name is given to such organization and it should be registered. It should have a legal entity. Like we have Ram Krishna Mission, Ananda Marg. These are some religious denominations where it is registered and it could manage its own affairs. But as we say, Aurobindo Society is not a religious denomination. Arya Samaj also, even Arya Samaj, this is also not a religious denomination or organization. We have many other sects which follow, which manage their own affairs, which do establish their institutions. So we have all those things where we have given, the Constitution has given the freedom to manage our own religion. And till now, we have discussed main fundamental rights, right to equality and right to freedom. In our today's class, we would be discussing right against exploitation. This right against exploitation, here we have two articles, Article 23 and 24. So when we say fundamental rights, again just to revise, fundamental rights are placed in Part 3 of the Constitution, and these rights are very important for the existence of individual and for the progress of the country. So right against exploitation. The word exploitation is very comprehensive word. What exactly exploitation is? So we will be going into this, that is right against exploitation, Article 23 and 24. So we just need to understand, we had a very long culture in our country especially, where poor people, illiterate or any other peasants were exploited by Britishers, before them by rulers of various rulers. So people, a general people, common man has been exploited. Exploitation here is making them work without their will. That is, a person is working without being given compensation for that work. So that is exploitation. Exploitation could be of various types: physical exploitation, mental exploitation, cultural exploitation, all these. So in our Constitution, after framing our Constitution, our founding fathers, our framers of the Constitution have thought that all those social evils like slavery, like bonded labor, like various other exploitations should be banned in our free India. So we thought of adding right against exploitation in our fundamental right, because we have seen many people has been exploited in various ways. They may be plantation workers or BD cigar workers or any farmers, peasants. You take any common man, they have been exploited at very crude way. So when we say in our Constitution right to equality, right to freedom and all things whatever we have in preamble, that is justice, fraternity, equality. So all this is only possible when we treat human being with dignity. So when the dignity counts, we say every common man, every labor, every children, every woman should be treated with dignity. Dignity of labor, whatever the work they do should be paid. So paid in cash, kind or whatever. So right against exploitation is an important fundamental right which protects which protects a person to work with his interest, not against his interest. If anyone makes a person to work against his will, he would be punished. That is what we say prohibition. State prohibits, state limits a person to exploit a common man. So when we say traffic in human beings, trafficking is important word here, where human beings are treated as commodity. Commodity means a good or goods. Where human beings are treated as goods, then we call it as trafficking in human beings. So why we use this word traffic? Because we have many such words. We have words like slavery, we have words like bonded labor and other things, exploitation, etc. So we have chosen the word traffic in human beings. Traffic is a comprehensive word which includes all these things: slavery, bonded labor, or paying less to the labor, or compensating less to whatever they work. So we have used this word traffic in human beings. Human beings include everyone, every human being, be it man, women, children, or any other person who is treated as a commodity. That is, earlier people used to get sold. People used to buy person to get them into slavery or to make them work in very hazardous situations, or they made them work below the dignity. So all these have been prohibited in our constitution by Article 23. So 23 gives human being a dignity of labor. So when we say forced labor, what does that mean? You are forcing someone to act in the way they don't like. Suppose if someone is not interested to that work and the particular person is making them to work in that way, so he is forcing to act against the will of the person. That is called forced labor. So forced labor is without the will that person is made to work. So here it could be anything. He can be made to work anything which is against his interest. So that is prohibited by the state, by Article 23. If anyone means state, a company, person, private person, anyone makes a person to work against his will, he will be punished. So we have prohibited all such kinds of forced labor. So here we have seen many landlords earlier. Many landlords used to hire people to work in their plantation, to work in their field, to work in their estates. So these workers were forced to work in those fields, and the landlords were not giving payment for their work. So when we say forced labor, we say any person, ఏ వ్యక్తి అయినా వాళ్ళకి ఇంట్రెస్ట్ లేని పనిని చేయిస్తే అది ఫోర్స్డ్ లేబర్ కింద వస్తుంది. సో అది ఒక బలవంతంగా వాళ్ళ మీద బలవంతం చేసి పని చేయించుకోవడం. సో ఈ సిస్టమ్ని ఈ ఆర్టికల్ ప్రొహిబిట్ చేస్తుంది. అది స్లేవరీ కావచ్చు, లేదంటే ఎవరినైనా బాండెడ్ లేబర్, ఫర్ ఎగ్జాంపుల్ చైల్డ్ లేబర్ లాగా ఎవరినైనా పెట్టుకుంటే అది ఫోర్స్ఫుల్గా పెట్టుకోవాల్సి వస్తుంది. సో ఈ జమీందార్ సిస్టంలో, ఆ టైంలో జమీందార్ సిస్టంలో చాలామంది సిటిజన్స్ని బలవంతంగా వాళ్ళ ఎస్టేట్లో కానీ వాళ్ళ ల్యాండ్లో కానీ పని చేయించుకునేవాళ్ళు. అలాంటిది దే హ్యావ్ సెడ్ దట్, అలాంటిది మామూలుగా అంతకుముందు నడిచేది. బట్ స్వతంత్రం వచ్చిన తర్వాత మన కాన్స్టిట్యూషన్ని రాసుకున్న తర్వాత వీటిని మనం ప్రొహిబిట్ చేశాము. So very important article when we say traffic in human beings. Once again I am saying traffic is a comprehensive word where it includes slavery, bonded labor, or any such work which is made to work by any citizen without his will or interest. That is one thing. This will be going into detail. Second article, Article 24, says, so here we say traffic in human beings, and this article specially talks about children. Specially talks about children under the age of 14 years. Children under the age of 14 years should not be made to work in any hazardous places. హెజార్డస్ ప్లేసెస్ అంటే ఎక్కడైతే వాళ్ళ ప్రాణానికి అపాయం ఉంటుందో అలాంటి పరిస్థితిలో వాళ్ళు ఎక్కడ పని చేయించుకోకూడదు. సో అవి ఎలాంటి ప్లేసెస్? ఫ్యాక్టరీస్ ఉండొచ్చు, కోల్ మైన్స్ ఉండొచ్చు, రైల్వే వర్క్ ఉండొచ్చు, కన్స్ట్రక్షన్స్ ఉండొచ్చు. సో ఇలాంటి ఫీల్డ్స్లో children below the age of 14 should not be employed. So that we have prohibited under Article 24. There is a small difference. What we need to understand is under Article 23 we have prohibited traffic in human beings. Traffic ante oka manishini oka vastuula పరిగణించే ఒక టర్మినాలజీ. సో ట్రాఫిక్ ఇస్ ఒక మనిషి కానీ అది ఎవరైనా కానివచ్చు, పురుషుడు, స్త్రీ, పిల్లలు ఎవరైనా, వాళ్ళని ఒక కామోడిటీ అంటే ఒక వస్తువులా పరిగణించి వాళ్ళని కొనడము, వాళ్ళని అమ్మడము అలా చేస్తే దాన్ని మనం ట్రాఫికింగ్ ఇన్ హ్యూమన్ బీయింగ్స్ అంటాము. సో అది ఏమైనా జరగవచ్చు. ఫర్ ఎగ్జాంపుల్, ఫీమేల్ మే బి ఫోర్స్డ్ టు గో ఇన్ టు ప్రాస్టిట్యూషన్. Children may be forced to get into work or prostitution. So all these things generally what we have seen and what is still being made in this modern place also, modern state also. Though we have such a stringent articles, many sections in IPC, CRPC, Civil Procedure Code, still we witness all such things, all such social evil things. But the state is so harsh on those that if they've been caught, they will be punished very harshly. And we believe we could stop this practice because since 75 years of our independence, we have almost done in a very good way because we have such a stringent laws. That is one thing. And when we talk about Article 24, we specially talk about children under the age of 14. Again, when we have amended this article, we have also added adolescent. We have also added adolescent, that is between age of 14 to 18. So we have two special things when we talk about children. They are less than 14 years of age. When we say adolescent, they are between 14 and 18 years of age. So that is the basic introduction about Article 23 and 24. Now we would be getting into detail. So we have learned what this article says. It says exploitation. We are prohibiting exploitation. Exploitation could be of various kinds. So you may exploit physically when you make a people work beyond the limited hours, or when you make them work with a little compensation or little salary, or you may psychologically affect such persons. So all this may be they all come under exploitation. You are exploiting in all such aspects. There may be a social exploitation too. So now we get into the detail of Article 23. As I said, Article 23 specially, so it is a bigger comprehensive word where we are talking about human beings. Article 24 specially talks about children and adolescents. So what Article 23 says? Traffic in human beings and the begar system. Begar system is a Hindi word. It is a Hindi word used in North India. Telugulo begar ni vetti chakiri antamu. Vetti chakiri ante manaki telusu. Oka manishini panilo ఉన్నప్పుడు వాళ్ళకి ఎటువంటి కంపెన్సేషన్ ఉండదు, వాళ్ళకి ఎటువంటి పేమెంట్ కానీ శాలరీస్ కానీ ఉండదు. ఒకవేళ ఇచ్చిన ఆ శాలరీ వాళ్ళు చేసే పనికి తగ్గట్టు ఉండదు. సో ఇది ఎన్నో సంవత్సరాల నుంచి మన దేశంలో నడుస్తుంది. కొన్ని సందర్భాల్లో ల్యాండ్ లార్డ్స్, పెద్ద రైతులు, భూస్వాములు వాళ్ళ దగ్గర పనిచేసే వాళ్ళకి తరాలుగా చేస్తున్న వాళ్ళకి ఎటువంటి శాలరీ కానీ ఎటువంటి కంపెన్సేషన్ కానీ లేదు. సో వాళ్ళ పిల్లలు చాలామంది ఆ ఫ్యామిలీనే సర్వ్ చేసుకుంటూ వచ్చారు. జనరల్గా ఈ పీజెంట్స్, ఈ రైతు కూలీలు అంటాము, వాళ్ళు ఏదో అవసరానికి వాళ్ళ దగ్గర ఏదో ఒక లోన్ తీసుకోవడము, అది తీర్చలేక వాళ్ళ భూములను అమ్ముకోవడము, లేదంటే ఆ భూస్వాముల దగ్గరే జీవితకాలం అంతా పనిచేయడము, ఇవన్నీ మనకి ఫోర్స్డ్ లేబర్ కింద, స్లేవరీ కింద, బాండెడ్ లేబర్ కింద చెప్పుకుంటాము. దాన్నే వెట్టి చాకిరీ అంటాము. సో వెన్ వి సే ట్రాఫిక్ ఇన్ హ్యూమన్ బీయింగ్స్ అండ్ ద బేగార్ సిస్టమ్, బేగార్ సిస్టమ్ని హాలి అని కూడా అంటాము. వి కాల్ ఇట్స్ హాలి, ఇట్స్ ఆల్సో a Hindi word. సో దిస్ బేగార్ సిస్టమ్ అండ్ సిమిలర్ ఫార్మ్స్, ఇక్కడ సిమిలర్ ఫార్మ్స్ అంటే ఇలాంటివి ఏవైనా, అంటే ఫోర్స్డ్ లేబర్లో స్లేవరీ కానివ్వండి, మామూలుగా వెట్టి చాకిరీ కానివ్వండి, ఇలాంటి ఏవైనా ఎనీ ఫార్మ్ విచ్ మేక్స్ ఎనీ హ్యూమన్ బీయింగ్ టు వర్క్ అగెయిన్స్ట్ దేర్ ఇంట్రెస్ట్, వాళ్ళ ఇచ్ఛానికి అగెయిన్స్ట్గా వర్క్ చేయించడం అనేది బేగార్ సిస్టమ్, అది ఫోర్స్డ్ లేబర్. సో దిస్ థింగ్ ఈజ్ prohibited under Article 23. So we need to understand the bigger concept of the word trafficking in human beings and exploitation. So other similar forms of forced labor, other similar forms, it could be anything, any form where a human being is not treated with dignity, not treated with dignity of labor. They are not paid according to the work what they have done. So definitely they are exploiting, and with that the landlord or the owner of the land is getting benefited, not that person. A person who is working in the field is not getting benefited, but the landlord is getting benefited. Here the landlord doesn't share his profit with those tenants. ఆ రైతు కూలీలతో ఆ యజమాని లేదంటే జమీందార్ కానివ్వండి, వాళ్ళ ప్రాఫిట్ని షేర్ చేసుకోవట్లేదు, ఓకే, కానీ వాళ్ళకి ఇచ్చే కూలీ కూడా సరిగ్గా ఇవ్వట్లేదు. సో తక్కువ డబ్బులతో ఎక్కువ పని చేయించుకోవడము, లేదంటే వాళ్ళని ఫిజికల్గా హింసించడము, ఇవన్నీ బేగర్ సిస్టంలో వస్తుంది. సో దాన్నే మనము ఎక్స్ప్లాయిటేషన్ ఆఫ్ హ్యూమన్ బీయింగ్స్ అంటాము. సో అది మనము ఆర్టికల్ 23తో ప్రొహిబిట్ చేస్తున్నాము. స్టేట్ ఏం చెప్తుంది, ఎక్కడైనా ఇలాంటి వ్యవస్థ, ఇలాంటి వెట్టి చాకిరీ వ్యవస్థ నిర్మూలానికి స్టేట్ ఎంకరేజ్ చేయాలి. అలా ఏదైనా జరిగితే అది ఒక నేరం కింద భావించాలి. సో ఆర్టికల్ 23 prohibits this system, Begar system, but if anyone involves in that, they are strictly punished. That is one thing. Again, what is Begar system? It is a compulsory work. It is not an option. It is not doing work voluntarily. స్వతహాగా చేస్తున్న పని కాదు, అది ఫోర్స్ఫుల్గా చేయించుతున్న పని. సో కంపల్సరీగా చేయాలి, లేదంటే వాళ్ళు ఇచ్చే పనిష్మెంట్స్ ఇంకో వేరే రకంగా ఉంటాయి. సో కంపల్సరీ వర్క్ వితౌట్ రెమ్యునరేషన్, వితౌట్ ఎనీ కంపెన్సేషన్, without any salary, without any wage, without any payment, a person is made to work forcefully. Example, as I said, local zamindars are landlords. Obviously they had 100 of acres of land and they need more people to work in their fields. So from where they would get such people? So a village, they will forcefully make those people to come and work, because they themselves, those villagers are poor peoples, they may not have that sort of land, and as they are poor people, they need money for survival. So what they do, they go by force, బెదిరించో కానీ ఏదో ఒక ఆశ చూయించి వాళ్ళని తీసుకొస్తారు వాళ్ళ ఫీల్డ్లో పని చేయించడానికి, and that leads to a cycle of bonded labor. ఒక దగ్గర ఎక్కడైనా ఒక అప్పు కానీ తీసుకుంటే ఆ ల్యాండ్లార్డ్ దగ్గర, అక్కడ వడ్డీ వేసి, చక్ర వడ్డీ వేసి, దాని అమౌంట్ని ఇంక్రీజ్ చేసేసి, అది తీర్చేంత వరకు మీరు మా దగ్గరే పని చేయాలి అనే ఒక కండిషన్ పెట్టి వాళ్ళని బయటికి రాకుండా అన్ని ఆప్షన్స్ యూజ్ చేసి బెదిరించో, ఫిజికల్గా టార్చర్ చేసో వాళ్ళ దగ్గరే పని చేసేలా పెట్టుకుంటారు. సో దట్ ఈస్ బేగార్ సిస్టమ్, అండ్ దట్ కంపల్సరీ వర్క్ వితౌట్ రెమ్యునరేషన్ ఈజ్ prohibited by Article 23. So now we have understand what Begar system is And what Article 23 says, it's a comprehensive word when we say traffic in human beings. ట్రాఫికింగ్ ఇన్ హ్యూమన్ బీయింగ్స్ అంటే ఒక మనిషిని ఒక వస్తువుగా భావించి వాళ్ళని అమ్మడము కొనడము అనే ఒక క్రియ. సో ఇక్కడ ఈ ఆర్టికల్ 23 కొన్ని ఎగ్జంప్షన్స్ కూడా ఇచ్చాయి మనకు. కొన్ని పరిస్థితిలో స్టేట్ అంటే ఎనీ స్టేట్, మనము ఆర్టికల్ 12లో డిఫైన్ చేసుకున్నాము. స్టేట్ అనేది ఒక పార్లమెంట్ కావచ్చు, లేదంటే పార్లమెంట్ సంబంధించి సెంట్రల్ గవర్నమెంట్ కావచ్చు, ఒక అసెంబ్లీ కావచ్చు, స్టేట్కి సంబంధించి స్టేట్ గవర్నమెంట్ వాటి అసెంబ్లీస్ కావచ్చు, లోకల్ బాడీస్, ఆల్ 3 tiers ఆఫ్ లోకల్ బాడీస్, మున్సిపాలిటీస్, పంచాయత్స్లో మళ్ళీ గ్రామ సభ, మండల్ పరిషత్, జిల్లా పరిషత్, ఏదైనా ఒక కంపెనీ, అది కార్పొరేట్ పబ్లిక్ సెక్టర్ కంపెనీ కానివ్వండి, రిజిస్టర్డ్ కంపెనీ కానివ్వండి, ఇవన్నీ స్టేట్లో వచ్చేవి. సో ఏ స్టేట్లో ఇలాంటివి ఏదైనా వ్యవస్థ ఉంటే అది ప్రొహిబిట్ చేయాలి. సో వెన్ వి సే ఎగ్జంప్షన్స్, కొన్ని ఎగ్జంప్షన్స్ ఉన్నాయి మనకి ఈ ఆర్టికల్లో. ఒక స్టేట్ ఈ సామాన్య పౌరులను ఒక ఎంప్లాయ్మెంట్ ఇచ్చి రెమ్యునరేషన్ లేకుండా పని చేయడానికి ఈ ఎక్సెప్షన్ ఉంది. For example, in many countries, Western countries, we have seen that at some age they have to serve in military. That is a system. Like every youth should at some point of time should give their voluntary service in their military. That exposes themselves to the surroundings. They become more patriotic. A sense of nationalism will develop in them. That again helps to this all things. I mean, nationalism, brotherhood, fraternity, whatever we call. So exception to this article, oka chinna minahaimpu endante, government could ask citizen to serve in military or any other such services without giving them any remuneration. వారికి ఎటువంటి పారితోషికం ఇవ్వకుండా వాళ్ళని సర్వీస్లో ఉపయోగించుకోవచ్చు. ఒక కండిషన్ ఏంటంటే, అలా గవర్నమెంట్ ఉపయోగించుకుంటున్నప్పుడు, వాళ్ళ సర్వీస్ని మనం వినియోగించుకుంటున్నప్పుడు అక్కడ మతము, కులము లాంటి భేదాలు చూపించకూడదు. ద స్టేట్ షుడ్ నాట్ డిస్క్రిమినేట్ ఎనీ సిటిజన్ టు టేక్ దేర్ సర్వీసెస్ ఆన్ ద బేసిస్ ఆఫ్ రిలీజియన్, రేస్, కాస్ట్, సెక్స్, ఎక్సెట్రా. సో దట్ ఈస్ వన్ ఎగ్జాంపుల్ and one exemption to Article 23. So for example, we have military services. Sometimes, example, we are in a war front. So at that time, the state could come with some order that the people under the age of bracket could come and should come and serve the nation. So there we cannot say that government is not paying us for this, because we are doing that for our security, for our integrity. We cannot demand remuneration or salary from the government, or the government could take the service without paying any remuneration. That is because now here we are serving the nation. We are not serving any private person. We are serving the nation, and nation has given us many things. So in emergency conditions, what if they ask us to serve, we need to serve without taking any remuneration. That is one exemption we have under this Article 23. This is an important word we need to remember in Article 23. One is trafficking in human beings, and in Constitution we have this begar system, which means vetti chakiri, forced labor. So as I said, what is force? Compelling అంటే వాళ్ళని కంపల్సరీగా పని చేయించుకోవడము, వాళ్ళ మీద ఒత్తిడి తీసుకురావడము, వాళ్ళ ఇష్టానికి వ్యతిరేకంగా పని చేయించుకోవడము. వాళ్ళకి ఆ పని చేసే ఇష్టం లేదు, అయినా వాళ్ళ మీద ప్రెషర్ చేసి వాళ్ళని ఆ పని చేయించడానికి ఫోర్స్ఫుల్గా తీసుకురావడము. దట్ ఈస్ compelling a person to work against his will, వాళ్ళ ఇంట్రెస్ట్ కి అగెయిన్స్ట్ గా, called as forced labor. We are forcing a person to do a work against his interest. That is forced labor. సో ఫోర్స్ అనేది ఒత్తిడి, అది ఏ రకంగా అవ్వచ్చు. అతనికి ఇష్టం లేని పనిని మనము ఒక ఒత్తిడితో చేయించుకుంటాము. సో ఆ ఒత్తిడి అనేది వేరియస్ రీజన్స్ ఉంటాయి. ఫర్ ఎగ్జాంపుల్, ఇట్ ఈస్ నాట్ ఓన్లీ ఫిజికల్. ఫిజికల్ అంటే ఏంటి? వాళ్ళని పనిష్మెంట్ చేయడము, వాళ్ళని ఫోర్స్ఫుల్గా కొట్టడము, బీటింగ్ అ పర్సన్ ఆర్ కంటైనింగ్ దెమ్, పనిషింగ్ దెమ్, దట్ ఈస్ ఫిజికల్లీ టార్చరింగ్ దెమ్. సో ఆ భయంతో వాళ్ళు పనికి ఒప్పుకుంటారు. అదర్వైజ్ వాళ్ళకి ఆ పని చేసే ఇష్టం ఉండదు. సో ఫిజికల్లీ టార్చరింగ్ అ పర్సన్ ఆర్ ఫిజికల్లీ మేకింగ్ అ పర్సన్ ఫోర్స్ఫుల్లీ టు వర్క్ ఈజ్ ఫిజికల్. అండర్ ఫోర్స్ we have various types. One is physical. సో ఇది మనం జనరల్గా చూస్తుంటాము. ల్యాండ్లార్డ్ సిస్టంలో, జమీందారీ సిస్టమ్స్లో కొరడాతో కొట్టేవాళ్ళు పని చేయకపోతే, అదర్వైజ్ హింసించేవాళ్ళు. ఆడవాళ్ళని అయితే ఇంకా దే యూస్ టు ట్రీట్ అ ఉమెన్ యాజ్ అ కామోడిటీ. there was nothing like morality or decency. There was no dignity. So such type of treatment was given to ladies specially, and that has made women or anyone, children, to work. So this unfortunately this system has been in our society for many long years, but after we got our constitution, we could prohibit this. We have almost eliminated this sort of torture or this sort of culture in our society. So force could be physical. Okay, let us, so it is not only about rural area. When we say forced labor, it may also be in various public sector and private sector companies. Even multinational companies of today are making their employees to work forcefully. They are working beyond the limit, beyond the work limit. For example, if we have 8 to 9 hours work under our constitution, or it's a norm generally followed across the world that a person should work for 8 to 9 hours a day. But many MNCs, we say white collar jobs, they are also working for 12 hours. So they are forcing, the organization is making those employees work more beyond their limits. వాళ్ళకు చేయాల్సిన సమయం కన్నా ఎక్కువ సమయంతో పని చేయించుకుంటున్నారు. సో అది ఫోర్సే, ఫిజికల్లీ ఫోర్స్ అది. ఎందుకంటే 8-9 అవర్స్ తర్వాత బాడీ ఎగ్జాస్ట్ అవుతుంది, టైర్డ్నెస్ వచ్చేస్తుంది. అయినా మనం చేస్తున్నామంటే కొన్ని కారణాల వల్ల, లేదంటే కంపెనీ శాలరీ తగ్గిస్తుంది, ప్రమోషన్లో ఆపేస్తుంది, ఇలాంటి కొన్ని కారణాలు ఉంటాయి. సో అది ఫోర్స్ఫుల్గా చేయాల్సి వచ్చింది. సో ఈవెన్ నాట్ ఓన్లీ పీజెంట్స్, నాట్ ఓన్లీ అగ్రికల్చర్ ఫార్మర్స్, నాట్ ఓన్లీ కన్స్ట్రక్షన్ లేబర్స్, ఈ ఫోర్స్డ్ లేబర్ అనేది పై స్థాయి వరకు కూడా ఉండవచ్చు. సో ఫిజికల్ ఫోర్స్ అనేది ఒకటి. లీగల్ ఫోర్స్, మనం లీగల్ ఫోర్స్ ఎప్పుడు అంటాము? ఫర్ ఎగ్జాంపుల్, వెన్ అ పర్సన్ ఈజ్ బీన్ రిక్రూటెడ్, ఒక కంపెనీలో ఒక ఎంప్లాయీగా రిక్రూట్ అవుతాడు. ఆ కంపెనీ ఆ ఎంప్లాయీతో ఒక బాండ్ రాయించుకుంటుంది. సో ఈ కంపెనీకి నేను మినిమం ఒక 2 సంవత్సరాలు సర్వ్ చేస్తాను, ఒకవేళ నేను ఈ 2-3 ఇయర్స్ సర్వ్ చేయని పరిస్థితిలో, ఆ బాండ్లో మెన్షన్ చేసి ఉంటుంది, సర్వ్ చేయని పరిస్థితిలో నేను కంపెన్సేషన్ ఇస్తాను అలా అని. సో ఈ లీగల్ ఫోర్సెస్ అంటే ప్రతిదీ చట్టబద్ధంగా రాయించుకోవడం ఒక ఎంప్లాయీతో. If any employee is entering into a bond or contract with the organization, then he is been forcing legally. What if there is no clause of paying compensation and breaking the bond or breaking the contract? ఒకవేళ మనకి కంపెన్సేషన్ ఇచ్చి లేదంటే ఆ పరిహారం చెల్లించి బాండ్ బ్రేక్ చేసే అవకాశం లేకుండా ఉంటే ఏమయ్యేది? That particular person has a legal bond, or when he is entered into the contract, he has to serve that organization against his will. అతనికి ఇష్టం లేకున్నా బికాజ్ హీ హ్యాస్ ఎంటర్డ్ ఇన్ టు ద బాండ్, ఒక కాంట్రాక్ట్ రాయించుకున్నారు కాబట్టి ఖచ్చితంగా పని చేయాల్సిందే. ఒకవేళ చేయని పక్షంలో కోర్టుకి వెళ్తారు. సో అది లీగల్ ఫోర్స్. This is what we see in many organizations. But okay, now because this article prohibits that, in legal contract we have some clause. If anyone enters the contract with any organization, be it public, private or any thing, if someone wants to break the contract, there is a provision that you need to pay some compensation or some amount which is mentioned in the bond, because that organization has invested some amount, some time on that employee, maybe in term of training, maybe sharing the infrastructure or such things. That company has invested time, money. So when that particular employee wants to come out of the organization before the time mentioned in the bond, that particular employee should pay the compensation. This is a clause. This is a clause under the bond or contract rules. But imagine what had if there is no such clause or no such section. That particular employee may not knowingly enters into the bond or writes the bond or signs the contract, and then he doesn't like the work, or he may not like the way the organization is functioning. There may be more bossism, there may be a hierarchy which he may not be interested in. So there may be many reasons, because he cannot work against his morality, against his ethics. So what he want to come out of that contract or work somewhere else? Then if he is forcing that employee, the organization is forcing the employee, but not by not making him to come out of the organization. So that is forced labor, and that is being prohibited by this article. As I said, bonds can be broken by paying some compensation. So that is legal force. There should be a difference between physical force and legal force. Physical force is physically torturing a person to do the work. Legal force is that particular person, there is an agreement between the employer and the employee. If employee breaks that agreement, then employer will sue him or go to the court. So that is one type of exploitation. Now what is economic circumstances? ఈ ఆర్థిక పరిస్థితులు అంటాము దీన్ని, ఎకనామిక్ సర్కమ్స్టాన్సెస్. కొన్ని పరిస్థితిలో డబ్బుల కోసం ఏ మనిషినైనా ఏ పని అయినా చేయించుకోవచ్చు అనే ఒక బ్యాడ్ థాట్ ఆర్ రాంగ్ ఇంటెన్షన్, ఐ వుడ్ సే. సో circumstances may be, for example, a person may have old parents at home, they need some medicines. In that conditions, that particular person may want to do anything, any hard work or any work which is not actually interested in him. So out of his interest, he has been forced because of such economic conditions, he is doing such work. And to take advantage of that bad economic condition of that particular person, some employer would make him to work more or work harder or work something which is ethically or morally not interested by him. So such economic circumstances, everyone will face sometime in their life these things where economic circumstances would force some people to work though they are not interested. Now we see many things. Child labor, కొంతమంది పేరెంట్స్ చిన్న పిల్లల్నే పనికి పంపించేస్తారు, ఎందుకు? వాళ్ళ ఆర్థిక పరిస్థితి బాగా లేదు కాబట్టి. కొంతమంది మహిళలు ప్రాస్టిట్యూషన్ సైడ్ ఫోర్స్ఫుల్గా వెళ్ళడం జరుగుతుంది, ఎందుకు? వాళ్ళ ఫ్యామిలీకి ఒక సపోర్ట్ లేదు, లేదంటే వాళ్ళ ఎకనామిక్ సర్కమ్స్టాన్సెస్ డిమాండ్ చేస్తాయి కాబట్టి. సో అలాంటి పరిస్థితిలో వాళ్ళని ఎక్స్ప్లాయిట్ చేయడము, వాళ్ళని వాళ్ళ ఇష్టానికి అగెయిన్స్ట్గా పనులు చేయించడము అనేది ఫోర్స్డ్ లేబర్. దట్ ఈస్ వాట్ వి సే. ఫోర్స్ అనేది మూడు రకాలు. వీ హ్యావ్ ఫిజికల్ ఫోర్స్, we have legal force, and also we have economic circumstances. So in economic circumstances or physical force or legal force, a person may made to work with little salary or sometimes with no salary also. With no salary also they are forced to work. They may just provide them with food or shelter and they made them to work for hours. So this also comes under forced labor, and that is prohibited by Article 23. Here we have seen this article supports, strengthens or encourages dignity of labor, equality, freedom. Freedom is, when we say forced labor, they don't have freedom to choose their work. They work against their liberty, against their freedom, against their conscience. So this article gives an individual or a person to work with dignity, to be liberty, to listen to their conscience. So this we need to understand. Again, broadly speaking, because this is an important article where a human being generally gets exploited. From ancient India to modern India, we have seen many things, and we have many movies, documentaries that actually shown this. So what trafficking is? Again, selling and buying of men, women and children. Immoral trafficking is when a person is pushed into prostitution, slavery or such things. దేవదాసి సిస్టమ్ మనము జోగిని సిస్టమ్ అంటాము తెలుగులో. వాట్ ఈస్ దేవదాసి సిస్టమ్? అగైన్ దిస్ ఈస్ డిపెండింగ్ అపాన్ ఎకనామిక్ సర్కమ్స్టాన్సెస్, సోషల్ సర్కమ్స్టాన్సెస్. ఇన్ ఎనీ ఫ్యామిలీ, ఇఫ్ అ గర్ల్ ఈజ్ ఇల్ ఆర్ నాట్ హెల్తీ ఆర్ మేబీ ఫ్రమ్ పువర్ ఫ్యామిలీ, ద పేరెంట్స్ వుడ్ గివ్ అవే దట్ ఫీమేల్ చైల్డ్ టు ద డెయిటీ. ఒక గుడిలో ఆ అమ్మాయికి అప్పగించేసేవాళ్ళు, దేవుడితో పెళ్లి చేసేసేవాళ్ళు. సో నో, వాట్ దట్ డస్ మీన్? డెఫినెట్లీ that girl will having no personal life. In the name of God, she will be getting exploited. She won't have any salary, any home or anyone of her own. Everyone would exploit her, because in the name of culture, in the name of protecting the art form like dance, music and all, the landlords or the person who are of high community would exploit those female. So that is Devadasi system, Jogini system mana culture lo undi, that we have prohibited. Dani valla oka social structure anedi debbatintundi. That Devadasi who has entered into Devadasi would be remaining single. Their children, because they don't have any father, they used to face many social discrimination. That is, psychologically they have been tortured, they have no identity of their own, and it has made the society very vulnerable. So we have prohibited this system of Jogini or Devadasi. As it says, slavery is వెట్టి చాకిరి కానీ ఏదైనా అవ్వచ్చు. ఒక మనిషి ఒక పని చేస్తే దానికి తగ్గట్టు వాళ్ళకి పే చేయకపోవడము, ఇష్టానుసారంగా వాళ్ళతో పనులు చేయించుకోవడము, కుటుంబం మొత్తం తరాలుగా వాళ్ళ దగ్గర సేవ చేయడము. సో ఇలాంటివి బానిసత్వం అనేది, ఇది స్లేవరీ. ఆ బానిసత్వాన్ని కూడా ఈ ఆర్టికల్ ప్రొహిబిట్ చేస్తుంది. సో దిస్ ఈజ్ టు ప్రివెంట్ ఆల్ ద అబోవ్, టు ప్రివెంట్ ఆల్ దీస్ థింగ్స్. Parliament has made an act, that is Immoral Traffic Prevention Act. This is specially for this thing where women, children are immorally trafficked, or they have been forcefully sold or bought. So we have many such acts passed by the Parliament. So we have few important acts, many acts. Bonded labor system, abolition of bonded labor system 1976. Bonded labor is a labor where he is forced to work. He was not allowed to go out of that zamindar. He has all rights on that labor. He used to torture him. He used to pay very little for his work. So this system has been abolished. When we say state should provide an opportunity of employment, state should provide a decent environment for work, state should pay equal for men and women, state should provide dignity of labor. So all these things, what we are experiencing was in reality bought by this act. So because we have Bonded System Abolition Act, any such act which encourages bonded labor are being punished. State prohibits, court punished. That is one thing. Minimum Wages Act. For any work, there should be a minimum salary, minimum wage. It is decided by various bodies. We have various commissions which says minimum wage should be there. So below that wage, no one should make a person work. So for example, ఒక కూలీ వాళ్ళు రోజుకు వారి కూలీ వాళ్ళు చేస్తే మినిమం ఒక 500 ఒక 600 అనేది ఒక మినిమం ఒక మార్క్ ఉంటుంది. అంతకంటే తక్కువ పని చేస్తే అది ఎక్స్‌ప్లాయిట్‌కి గురవుతున్నట్టే. సో అలా చేస్తే డెఫినెట్లీ it will become a crime. So we have Minimum Wages Act 1948. This is applicable in every organization, private, public, or any such things. So Contract of Labor Act. Any labor will get into the contract, and there is a clause to break the contract also. And employer cannot remove a person at his will. Arbitraryగా ఒక మనిషిని ఒక ఎంప్లాయీని తీసేయలేము. So these are the things what we have. Equal Remuneration Act. So male and female, because they give their work, and when we say equality, it is also equal treatment of women and men. So there is a act that supports this equality, where we say Equal Remuneration Act 1976. Okay, so we say bonded labor system. What is bonded labor system? It has existed for many years. If we have this in our culture since many years, we have abolished this. So when we have physical violence, sexual violence, all these things have been existed in bonded labor. When someone is under slavery, he doesn't have any option to get away of that work. అలాంటి పరిస్థితిలో చాలా రకాలుగా ఎక్స్‌ప్లాయిట్ కావచ్చు. అది మెంటల్ ఎక్స్‌ప్లాయిటేషన్, ఫిజికల్ ఎక్స్‌ప్లాయిటేషన్, సెక్షువల్ ఎక్స్‌ప్లాయిటేషన్, ఎనీథింగ్ కుడ్ హ్యాపెన్. ఆర్మ్ గార్డ్స్తో భయపెట్టి ఇలాంటి ఎక్స్‌ప్లాయిటేషన్ చేసేవాళ్ళు ఇంతకుముందు. సో జస్ట్ గెటింగ్ ఇన్ టు ద మినిమమ్ వేజెస్ యాక్ట్, దట్ ఈస్ వీఆర్ ఫిక్సింగ్ అ మినిమమ్ వేజ్. A minimum wage is always a guard against exploitation. ఆ మినిమం వేజ్ కన్నా తక్కువ శాలరీతో కానీ తక్కువ వేజ్తో ఎవరిని పని చేయించకూడదు. సో వీ హ్యావ్ ఫిక్స్డ్ దిస్ మినిమం వేజ్ బికాస్ ఇట్ ఈస్ ఎథికల్ టు గివ్ అ డీసెంట్ వేజ్ టు ద వర్కర్. ఎంప్లాయర్ విల్ గెట్ డీసెంట్ వర్క్. అందుకే మనం చూస్తాము జనరల్గా ప్రైవేట్ సెక్టర్లో కానీ పబ్లిక్ సెక్టర్లో కానీ ఎవ్రీ ఇయర్ ఒక ఇంక్రిమెంట్ ఉంటుంది. ఎవ్రీ 5 years ఒక కమిషన్ ఎంత శాలరీస్ పెంచాలో అనేది డిసైడ్ చేస్తాయి. సో మనకి తెలుసు ప్రతి సంవత్సరం రేట్స్ పెరుగుతూనే ఉంటాయి. దెర్ విల్ బి లైక్ వాట్ వి కాల్ ఇన్ఫ్లేషన్. ప్రతి సిటిజన్ విల్ ఫేస్ some challenges, like he have to save for their children, he have to work, he have to buy some things for their family. So every year there should be some increment. It is a sort of appreciation for the work he is doing. So that should be followed by private and public organizations or any such organizations where there is a organization, employee and employer. So on these grounds we have such acts. We have Contract of Labor Act 1970. This is, we are entering into the contract so that the employer ఎవరైతే మనకి ఉద్యోగం ఇస్తారో వాళ్ళు వాళ్ళ ఇష్టానుసారంగా తీసేయలేరు. ఒక బాండ్ ఉంటుంది. తీసేయకుండా ఉండడానికి we have many unions ఫామ్ అవుతారు లేబర్స్. సో ఎప్పుడు పడితే అప్పుడు తీసేయలేరు. ఒకసారి ఒక ఆర్గనైజేషన్తో ఒక అనుబంధం ఏర్పడితే if there is a relation between employer and employee, that should exist for some time. And removal అనేది కూడా ఆర్బిటరీగా ఉండకూడదు. There should be a reason. So to prevent exploitation, we have introduced this law, and also to prevent abuses in the system, we have this Contract Labor Regulation and Abolition Act 1970. That is one thing. We have equal remuneration, that is to pay equal for men and women workers. This is, we are not discriminating on the basis of sex. So on the basis of sex, we should not discriminate a person. So this is one thing, we are giving equal importance. Obviously, we have many other things which are provided by the organization or by the employer. For example, for women, we have maternity leave, special provisions when a female worker is pregnant, or for their children, we have some sort of schooling system. So we have many such compensation packages. So that is one thing. And to provide increasing opportunity to women, and it is to set up an advisory committee to promote employment opportunities. So every time and again there should be a committee which decides on such matters of employment to women in particular. We have discussed right to freedom, that is right to freedom of religion. We have discussed Article 25 and 26. We'll continue with the same thing, that is freedom of religion, and under Article 27 we are dealing with freedom for taxation, that is freedom for taxation for promotion of a religion. Article 27 again talks about religion, because freedom of religion is from Article 25 to Article 28. These are the 4 articles which talks about right to freedom of religion. Article 27 says no tax should be collected on the name of religion. That is, the state should not levy any tax for the religious purpose, or in other words, it says that the state should not spend general taxes, money occurred from general taxes on any particular religion. So we have 2 things here. One is, on religious basis the state shall not levy taxes, and second thing is, it should not spend the money on any one particular religion. So taxes అనేది అది ఒక పార్లమెంట్ యొక్క చట్టపరంగా అమలు చేసే ప్రక్రియ. కలెక్షన్ ఆఫ్ ట్యాక్సెస్, మనం పన్ను తీసుకుంటున్నామంటే అది జస్ట్ ఒక మతం మీద బేస్ అవ్వకూడదు. అలాంటివి జనరల్ ఫండ్స్ అనేది మనము ఒక ప్రత్యేక మతం మీద స్పెండ్ చేయకూడదు. సో దట్ ఈస్ వాట్ ఆర్టికల్ 27 సేస్. బట్ వీ హ్యావ్ సర్టెన్ ఎగ్జంప్షన్స్ హియర్. Not only taxes shouldn't be collected, but the amount can be raised or through fee that particular organization or entity can generate income. That is, they can levy fee or they can charge some fee for the provision of special services to those people who come and visit that place. For example, services to pilgrimage, laying of roads, construction of cottages, or improvement of temple, or charitable purposes like free food, shelter, etc. All these can be done by levying fee or by collection of fee. So no taxes can be levied. This article prohibits levy of taxes, but that particular organization can collect fee from the pilgrimage or from the people who believes in that religion. That is one thing. And these fee which are collected for that purpose should be spent on those purpose which are related to that religion. That fee can also be spent on educational institutions to provide service for the pilgrimage or for the development of that particular religion. I said endowments. Fee can be levied on religious endowments for meeting the regular expenditures. For example, in any Hindu temple, if you visit, there will be charging some fee. They may call as a regular darshan or special darshan, or in terms of offerings in hundi. So the fees that are collected through these things, through these channels, are spent on those purposes, on religious purposes. So here Article 27 prohibits collection of taxes in the name of religion, and also it prohibits the state's expenditure for any particular religion. When I say any particular religion, the state can spend its expenditure on all the religions proportional to their population. So every religion is given equal importance. No religion should be given priority or importance which neglects other religion. So that is the concept of secularism here. The secularism concept, what we follow is, state has no religion, but state has to see all religions equally. State has to give equal importance to all religions. That is a unique concept of secularism. So in Article 27, two main things is no taxes for the promotion of any particular religion. It can levy fee, it can collect fee. That is, it can collect for the development of that particular religion. That is Article 27. So moving on to Article 28, this is the fourth important article in right to freedom of religion. So no religious instructions shall be provided in any educational institutions. Important here is religious instructions. So as we know, every religion has its own doctrines. They follow their own rituals. They follow their own faith, unique things. They believe in some doctrines or rituals. So no religious instructions. If we see this no religious instructions, this is a general word. Here we say the state run institutions should not follow any religious instructions. Any institutions, be it school, college, or anything which is wholly run by the state. That is, it is completely funded by the state, and state maintains that religious institution or any other institution. In such institutions, there shall be no religious instructions. Religious instructions, when I say, it may be in the form of prayer, it may be in the form of following certain rules which are religious in nature. For example, ఒక స్కూల్, గవర్నమెంట్ స్కూల్లో మీరు రిలీజియస్ ఇన్స్ట్రక్షన్స్ని ఇంట్రొడ్యూస్ చేయలేరు. ఎందుకంటే అది స్టేట్ రన్ కాబట్టి. ప్రతి ఫండ్ గవర్నమెంట్ నుంచి వెళ్తుంది. టీచర్స్, గవర్నమెంట్ టీచర్స్ ఉంటారు, వారు శాలరీ గవర్నమెంట్ నుంచి తీసుకుంటారు. ల్యాండ్, బిల్డింగ్ అంతా గవర్నమెంట్ ప్రాపర్టీ ఉంటుంది. సో అలాంటి ప్రభుత్వ విద్యాలయాల్లో కానీ, ప్రభుత్వ కళాశాలల్లో కానీ, ప్రభుత్వ యూనివర్సిటీస్లో కానీ రిలీజియస్ ఇన్స్ట్రక్షన్స్ అనేది చేయకూడదు. అయితే ఒక మతానికి సంబంధించి ఏ ప్రాక్టీస్ ఫాలో అవ్వకూడదు. ఇట్ ఈస్ నాట్ దట్ అదర్ ఇన్స్టిట్యూషన్స్ విచ్ ఆర్ రికగ్నైజ్డ్ బై ద స్టేట్ బట్ అడ్మినిస్టర్డ్ అండర్ సమ్ ఎండోమెంట్స్. ఎండోమెంట్స్ అంటే అది రిలీజియస్ క్యారెక్టర్స్ కిందనే వస్తుంది. ఫర్ ఎగ్జాంపుల్, వెన్ వి సే తిరుమల తిరుపతి దేవస్థానం, అది ఒక ఎండోమెంట్. వాటికి సంబంధించి చాలా స్కూల్స్, కాలేజెస్ రన్ అవుతున్నాయి స్టేట్లో. అలాంటి ఒక ఎండోమెంట్స్లో రిలీజియస్ ఇన్స్ట్రక్షన్స్ చేసుకోవచ్చు. దేర్ క్యాన్ బి హ్యావ్ రిలీజియస్ ఇన్స్ట్రక్షన్స్ బికాజ్ that particular institution is built or established for the promotion and progress of particular religion. When we say madarsas, it is an Islamic institution and it is particularly established for the progress and development of Islamic religion. Students come there, they learn Islam, they profess Islam, they propagate, and it is useful for promotion of their religion. So nothing is mentioned that the state should interfere in that. If it is a endowment in nature, that is, if it has a religious backup, so their religious instructions can be followed. And we also have other type of institutions, for example, private school or private colleges recognized by the state government or central government. In those institutions, religious instructions can be followed only on the consent of such student or person. So when we say, when there is partially aided or private school which is recognized by the state, they may follow such religious instructions provided the consent of such person is taken. In case of minors, their guardian should give the consent. So when we say we have a Catholic school, Christianity school, or a Muslim Islamic school, or Hindu bent school, in these schools the consent, because we don't have only students from that particular community, though they are a minority established schools, but people from different communities also be there. So it is not compulsory on anyone that they should follow religious instructions. Before that, if they want to impose on them, that is not good. Look, that is against the law. They have to take the consent of the student or the person to be followed if there is a religious instructions. So that is one thing. So this religious instructions in educational institutions, no person attending any educational institution take part in any religious instructions that may be imparted in such institutions. Here such institutions is purely government institutions, that is funded and aided by the state. We have exception here. If there is a consent of the person, then they can participate. So minors, they cannot give their consent as their age is not legal here. So for minors, their guardian's consent need to be taken. So Article 28 distinguishes between 4 types of educational institutions. As I said, it's a repetition. Wholly aided or funded institutions, that is government colleges or schools or any such place of education where the following of religious instruction is prohibited. Here no religious instructions should be made. In administered by the state but established under endowments, here they can make the instructions, religious instructions, to be followed. And in recognized by the states, recognition in sense, the state will recognize for any schools or colleges, they will give a recognition number. So in this, in both of this, recognized and receiving a partial aid from the state, in both these cases, the religious instructions can only be followed, or the instructions can be given to those students who have no problem with following those religious instructions. No one is compelled to follow those religious instructions in the form of prayers, rituals, or any such thing. No one is compelled. These instructions are not mandatory. It is up to that particular person or student to follow them or not to follow them. So that is the importance of your consent. No one will force you to. If anyone is forced, then this article gets violated. You could approach the court. If anyone compels you to follow, or anyone compels a person to follow a religious instructions in any private, that is schools or colleges recognized by the state, other than established under the endowment or trust. So this is an important topic here, when we say religious instructions, we have many problems. We had many cases also in Supreme Court. So this article, that is freedom of religion, has a direct impact on secularism of the nation. We also have few articles which gets affected. That is Article 15 Clause 1. What this article says: no person shall be discriminated only on the basis of religion, race, caste, sex and place of birth. So here discrimination is prohibited. So when we say no person should be discriminated on the basis of religion, this article also gets violated. If on the basis of religion a person is discriminated, then it is unconstitutional. At the same time, we also have Article 16 Clause 2. This article says the state shall not discriminate offering an employment only on the basis of religion. So provision of employment should not be discriminated only on the basis of religion. So he may have other grounds like qualification, like other things like technical education and all, but not only on the ground of religion. So these things are related to Article 25 to 28, because here under Article 25, 26, 27, 28 we talk about freedom of religion, and under Article 15 Clause 1, Article 15 Clause 2 and 16 Clause 2 we talk about discrimination here, and here provision of employment on the basis of religion. So this is right to freedom of religion, which emphasizes, which guarantees an individual or a person to take any religion or to change any religion or to follow, practice or propagate their religion beliefs. So that is not the case that if you have freedom of religion, you would compel anyone to convert. So we have a case in Supreme Court. There was a case in 1977 in Kolkata that a father has appealed a petition. By petition is appealed that the process of propagation is spreading the religion. It also includes conversion of the people to their religion, that is Christianity. That case has been in Supreme Court, and Supreme Court said that here the word propagation does not mean that you could convert others forcefully on the basis of allurement or giving some money or such things. So we have a right to freedom, but that does not mean that someone is compelled to convert to other religions. Their conscience is hurting. They may not believe in that religion to which they are being forced to take. So here, forcing someone by using all those things like alluring them to good service, good future, money or any such things, no one should be compelled. So that is against one's conscience. That is, we say inner freedom. Here he is not following his heart or soul. Someone is influencing him. A person is getting influenced by such things. So he is forcefully changing his mind to take other religion. That is prohibited by our constitution. Otherwise, every person has freedom to listen to his conscience, to profess, to propagate, to practice all the religions or more than one religion also at times. When we say secularism, it does not mean we should be neutral. Anyone can practice one religion. If a person practices Hindu, it doesn't mean he is not secular. If a person practices Islam, we cannot say that he is not secular. Being religious is not against secularism. Secularism here is respecting all religions equally, respecting the sentiments of all religions equally. So that is the importance of right to freedom of religion. So we just see our right to freedom of religion in a holistic manner. We have done Article 25, 26, 27, 28, and this right to freedom of religion here, what Article 25 says. So we have freedom of conscience, profession, practice and propagation. Conscience is listening to your inner voice, what your inner voice says. Like you can connect to God in any way you want, or in any creature in any way you want. So how you connect with the God, goddess, or maybe not believing in God also. You may not have any God in your mind, but some superpower that you want to connect to. That is what religion is. So conscience is inner freedom. When I say profess, you will tell someone about what religion you are following. Practice is the practice of rituals, the practice of those doctrines and rituals what is mentioned by the religion scriptures. And propagation is when you are spreading your religion, you are making known to other people about the religion you are following. So Article 25 is your personal thing. There you personally feel that you need to profess or practice some religion. And this is a group. We can say that a religious entity, a religious organization, when it is established, will grow gradually. So you will own buildings, you will own lands, temples are there, mosques are there, churches are there. There are movable and immovable properties. So that is managed by such organization, and state should not intervene in that. So you have freedom to manage religious affairs. This is also have restricted under some grounds. There the state can restrict on economic, financial and political activities of such religious organizations or religious denominations. If in any case you are getting, or any organization, any religious organization is getting funds from different parts of the world, then the state could supervise such funding, because in many cases there may be misuse of such funds. The funds could also be easily diverted for antisocial elements. The funds could also be a threat to the sovereignty and security of the state. There may be a threat to public order, to morality, to public health. So state has all the right to intervene when such economic or financial transactions are being misused or diverted for not religious purpose. So we have state could intervene, but that is only when there is a threat. Otherwise, state generally does not interfere. So you have all the freedom to manage religious affairs. That is Article 26. 27 talks about taxation. No person should be compelled to pay tax in the name of religion. The state shall not levy any tax only on the base of religion, and whatever the tax or the amount collected or the expenditure, the state should spend on all religions equally, proportion to their population. So those endowments or those organizations, those denominations can collect fee. So fee is different from taxation. Fee is collected to provide service to those people who come to such denominations. So fee is to give better services for those people, for pilgrims. That is, they can spend that in expansion of their religion, to provide good facilities in terms of health, education, shelter, etc. So freedom from taxation is no one should compel one to pay the tax. And we have Article 28, which says that the state should prohibit the following of religious instructions in state funded institutions. in wholly funded institutions, that is state institutions, government colleges, government universities, government schools, there shall not be, no one should follow, that is the state, anyone should not compel to take religious instructions. But we have few categories in this. You are free to attend, or you cannot compelled, you cannot made to forcefully attend to such religious instructions. If the institution is of endowment in nature, definitely they follow their own religious instructions there. Third category is if any institution is recognized by the state or partially aided by the state, then without consent that person cannot follow any instructions, or no one should compel such person to follow religious instructions. So a minor can follow such religious instructions only on the consent of their guardian. So this is what we have in right to freedom of religion. As I said, this article is directly related to the concept of secularism. So we need to be very balanced, and all the steps should be taken to give this freedom to the people, and the state shall not interfere in internal matters of religion until and unless there is a threat to public order, morality and public health. So we have done with habeas corpus, mandamus and prohibition. Just a small revision. Habeas corpus is to bring the body, mandamus is to command, and prohibition is to prohibit. Habeas corpus is issued against an illegal detention. It could be issued for both public and private authority or person. Mandamus is issued only to public authorities. We have seen public offices, judiciary, corporations, such thing which has a statutory entity or a statutory background. And prohibition is a writ which is issued by a superior court to the inferior courts. Even the writ of certiorari is similar. So the literal meaning of the writ certiorari is to be certified, that is to be informed. This writ is also issued by a superior court to the inferior courts. So this writ of certiorari is issued by a court higher in authority to a lower court or tribunal, ordering them either to transfer the case pending or to quash their orders. So we have two important things. ఒక పై స్థాయి కోర్ట్ ఒక కింద స్థాయి కోర్ట్కి ఈ రిట్ ఇష్యూ చేయవచ్చు. సర్టిరరీ అంటే టు బి సర్టిఫైడ్, టు బి ఇన్ఫార్మ్డ్, తెలియజేయాలి, సర్టిఫై చేయాలి, ధృవీకరించడం అంటాము. సో ఒక పై స్థాయి కోర్ట్ కింద స్థాయి కోర్ట్కి ఈ ఇష్యూ రిట్ చేస్తుంది. ఎలాంటి సందర్భంలో? ఆ కింద స్థాయి కోర్టులో ఒకవేళ ఆ జ్యూరిస్డిక్షన్ కానీ ఆ ప్రొసీజర్ కానీ if it is different, then the higher courts or the higher authority can give an order to transfer such case to the higher authority courts. ఆ చిన్న తక్కువలో ఉన్న కోర్ట్ని ఆ కేసెస్ని మాకు ట్రాన్స్ఫర్ చేయమని పై స్థాయి కోర్ట్ అడగవచ్చు. లేదంటే ఆ ఇచ్చిన జడ్జిమెంట్ని క్వాష్ చేయమని కూడా ఆర్డర్ చేయవచ్చు. So these are the two things. One is the higher authority court could order the lower authority court or inferior court to transfer such case, and also could issue writ to quash such orders. So basically the writ of certiorari having been implemented in 3 cases. When the inferior court has no jurisdiction, ఒకవేళ వాళ్ళ పరిధిలో ఆ కేస్ లేనప్పుడు, దట్ ఈస్ వెన్ వీ హ్యావ్ ఎక్సెస్ ఆఫ్ జ్యూరిస్డిక్షన్ ఆర్ ద కోర్ట్ ఈస్ యాక్టింగ్ ఇన్ ఎక్సెస్ ఆఫ్ జ్యూరిస్డిక్షన్, ఆ కోర్ట్ పరిధిని దాటి ప్రొసీడింగ్స్ ఒకవేళ తీస్తే, దట్ హయ్యర్ కోర్ట్స్ క్యాన్ ఇష్యూ అ రిట్ saying that to transfer such case to higher authority courts. And we also have lack of jurisdiction. One is excess of jurisdiction. ఆ jurisdiction రాకున్నా jurisdiction దాటి, ఆ jurisdiction పరిధి దాటి ఒకవేళ కేసెస్ తీసుకుంటే, అలాంటి కేసెస్ని మాకు ట్రాన్స్ఫర్ చేయండి, అది మీ హద్దులో లేదు, అది మీ jurisdictionలో రాదు అని పై స్థాయి కోర్ట్ ఆర్డర్ ఇవ్వచ్చు. లేదంటే అది మీ జ్యూరిస్డిక్షన్కి సంబంధం లేదు అని కూడా ఇవ్వచ్చు. అదర్వైజ్ ఎర్రర్ ఆఫ్ లా, ఇఫ్ ద ఇన్ఫీరియర్ కోర్ట్ హ్యాస్ డన్ సమ్ మిస్టేక్ ఇన్ గివింగ్ ద జడ్జ్మెంట్ ఆర్ ఇట్ హ్యాస్ నాట్ ఫాలోడ్ ద డ్యూ ప్రాసెస్ ఆఫ్ లా, అలాంటి సందర్భంలో కూడా చిన్న స్థాయి కోర్టుకి పై స్థాయి కోర్ట్ ఈ రిట్స్ జారీ చేయవచ్చు. Three important things we need to know. One is excess of jurisdiction, one is lack of jurisdiction, and one is error of law. These are the three grounds on which the higher level courts or superior courts could issue the writ of certiorari to inferior courts, saying that you have acted in excess of your jurisdiction, or you do not have the jurisdiction or the limits to take that case, or the inferior courts have done a mistake in interpreting the law. So there is also an error of law. On this basis, the superior court could order the inferior court to transfer the case to the higher courts or superior courts on this three bases: excess of jurisdiction, lack of jurisdiction, and error of law. So we say the writ of certiorari is also between superior courts and inferior courts. Here we also say tribunals. Even these are the quasi-judicial bodies. So here, pre-1991, this writ of certiorari has been issued only for judicial authorities. But after that, we have also added that administrative authorities could also be issued these writs. Only administrative authorities. Here, we do not issue these writs to legislative bodies or private individuals. So now the case is, the writ of certiorari could also be issued against administrative authorities. So we have an example here regarding the writ of certiorari. When we say this writ is issued by superior court to inferior court for lack of jurisdiction, for excess of jurisdiction, or for error of law, to transfer the case to the superior court or to quash that order. ఒక జడ్జ్ ఏదైనా ఒక పర్సన్కి సన్నిహితుడైతే, రిలేటివ్ అయితే, అలాంటి కేస్ తీసుకోకూడదు. వాలంటరీగా వీరు నా రిలేటివ్స్, తెలిసిన వాళ్ళు అని వేరే జడ్జ్కి అయినా వేరే కోర్టుకి ట్రాన్స్ఫర్ చేసేయాలి. ఒకవేళ అలాంటి సందర్భంలో చెయ్యకపోతే the higher courts can issue the writ, because you cannot give a favorable judgment. ఒక impartial judgment వస్తుందని నమ్మకం ఉండదు. Because the concerned person may be advocate, or maybe the person who have committed the crime, maybe he is the relative of that judge. So in that cases, voluntarily a judge has to give the cases or transfer the cases to other courts. In failure of that, the higher superior courts can issue this writ saying that you transfer the case to the other court. So that is an example, because here we say when lack of jurisdiction or error of law, anything could happen. The judgment may not be impartial. So this is an example of certiorari. Writ of quo warranto. Quo warranto is by what warrant? Warrant means authority. By what authority a person is performing the job? What authority do you have? Any public authority, if he is involved in implementing any action or performing his duty, that is, there need to be have some authority given by the statutory body. So literal meaning of quo warranto is by what authority. So we have this writ of quo warranto to ensure that a person should not do such work which violates their authority, or should not indulge in some activities which is not under their power. వాళ్ళకి ఉన్న పరిధులు దాటి, వాళ్ళకి ఉన్న పవర్స్ని దాటి ఏదైనా వర్క్ చేస్తే అలాంటి సమయంలో ఇలాంటి రిట్స్ ఇష్యూ అవుతుంది. రిట్స్ ఆఫ్ కో వారెంట్ అనేది ఇష్యూ చేయబడుతుంది. సో దిస్ ఈజ్ రిలేటెడ్ టు ద authority of that person, the power of that person. So the court will ask, by what authority you have done this work? So if the action of that public authority invalidates or encroaches the fundamental right of any citizen, that aggrieved citizen can move Supreme Court, and Supreme Court will issue a writ saying that by what authority you have done this work or issued these orders. So Supreme Court or High Court issues this writ to prevent illegal assumption of a power by a public office or public officer. So there is many of examples. You have to know that every public authority has guided by some service rules. They have some jurisdiction, some authority. They cannot indulge in such works which is not given in their service. Like, they have to be within the limits of the power. If such power is misused, if the power of any officer is misused, then the Supreme Court could issue this writ of quo warranto. We have an example here. For example, if a vice chancellor in a university has the authority to give opportunity or to recruit a person, but if such officer at higher level, that is vice chancellor, recruits any person in the university against the law or against the standards, be it qualification or something else, if he recruits a teaching staff or non-teaching staff against the standards, then the court could issue this writ of quo warranto. That is, the court asks that person, that is vice chancellor here in our example, by what authority you have recruited by not following all the norms. So this writ of quo warranto is a tool within the hands of Supreme Court and High Court to stop that a public officer misuses their power. So the misuse of power is a ground where the superior courts or High Court or Supreme Court could issue writs to particular person. So quo warranto can be issued only when substantive public officer, that is, who has a authority, who is a permanent officer. So only the officer who is permanent and who has acted against or over his power is liable to be issued this writ. It can't be issued against private or ministerial office. So here legislative body or ministerial office is, they cannot be issued writs against these offices. So this writ of quo warranto stops a person for illegal usurpation of the power. So all these writs of mandamus, writs of habeas corpus, writs of prohibition, writ of certiorari and writ of quo warranto guarantees their fundamental right against the encroachment of the state or private body. So when I say writs, it is the basic thing, fundamental thing. Under Article 32, these are the tools with Supreme Court and High Court to protect a person's individual liberty, to protect a person against the detention. So that is the reason why we call this Article 32 as the soul and heart of the Constitution. We also have one more writ, that is writ of injunction, which is actually not mentioned in our Constitution. So both High Court and Supreme Court has authority to issue writs. When I say Supreme Court, it is under Article 32. When I say High Court, it is under Article 226. Just to know this, the scope or the jurisdiction of the Supreme Court is narrower here. The jurisdiction of High Court is larger in issuing this writ, because the Supreme Court could issue writ only to enforce fundamental rights, and the High Court could issue writs not only to enforce fundamental rights, but it can also issue writs to enforce other ordinary or legal rights. That is why I say the scope of Supreme Court is narrow and the scope of High Court is wider. So only fundamental rights can be protected by the Supreme Court, but the High Court can issue writs not only for the fundamental rights but also for the ordinary rights. So territorial jurisdiction. Obviously, Supreme Court's jurisdiction expands to entire territory of India. That is, their judgments are enforceable in all parts of the India. High Court's judgment, that is the ruling, the jurisdiction of the High Court is within that state only. So when we say jurisdiction, obviously Supreme Court jurisdiction is much wider and High Court's jurisdiction is limited only to that state. Article 32. This power of Supreme Court of issuing writs comes under its original jurisdiction. So this article binds the Supreme Court to not refuse any person whose fundamental right has been violated. The Supreme Court is mandated to take that issue and give writs on such cases. So it is mandatory on the part of Supreme Court. So Supreme Court may not refuse to exercise its power to issue writs. And in case of High Court, it has a discretionary power, because High Courts can enforce both fundamental rights and other legal rights. It may or may not entertain such proceedings. Otherwise, we can also say that High Court has a discretionary power to issue writs. The High Court may or may not issue writs, but Supreme Court has to issue these writs because it comes under its original jurisdiction. So this is the gist of Article 32, very important article in fundamental rights. Entire fundamental rights, right from Article 14 to Article 35, rests on the Article 32. That is why Dr. B.R. Ambedkar has said Article 32 is the soul and heart of the Constitution, without which the entire Constitution is a nullity. So we have a meaning to the Constitution because this gives power to any person to approach court in case where their fundamental rights has been violated. So just these 5 writs are important. They have their own importance. They have their own circumstances on which the Supreme Court or High Court could issue writs. Habeas corpus, writ of habeas corpus. మన దగ్గర ఇంపార్టెంట్ ఇది 5 రకాల రిట్స్ ఉన్నాయి. habeas corpus, mandamus, certiorari, prohibition and quo warranto. ఈ డిఫరెంట్ రిట్స్ డిఫరెంట్ సర్కమ్స్టాన్సెస్లో ఇష్యూ చేయబడతాయి సుప్రీంకోర్టుతో కానీ హైకోర్టుతో కానీ. సో వాటి ఇష్యూ సుప్రీంకోర్టు ఏదైతే ఆ రిట్స్ జారీ చేస్తుందో అవి వేరే వేరే పరిస్థితిలో జారీ చేయబడతాయి. ప్రతి ఒక్క రిట్కి ఒక ఇంపార్టెన్స్ ఉంటుంది. సో కొన్ని రిట్స్ పబ్లిక్ అథారిటీకి అగేన్స్ట్గా జారీ చేస్తుంది, కొన్ని రిట్స్ కార్పొరేషన్స్కి, కొన్ని పెద్ద కోర్టు లేదంటే హయ్యర్ కోర్టు నుంచి కింద స్థాయి కోర్టుకి జారీ చేయబడతాయి. సో ఆల్ రిట్స్ ఆర్ నాట్ సిమిలర్. అన్ని రిట్స్ సిమిలర్ కాదు. ప్రతి రిట్స్కి ఒక స్పెసిఫిక్ రీజన్ ఉంటుంది, ఒక ప్రత్యేకత ఉంటుంది. సో వెన్ వి సే రిట్స్ ఆఫ్ habeas corpus, as we said, to bring the body, this Latin meaning is to have a body. When this writ is issued, this writ of habeas corpus is issued by Supreme Court or High Court when a person or any person detains other person. So this writ is issued when a person has been illegally detained or detained but not produced before the magistrate within 24 hours of detention. We have already had this under fundamental rights that any person who has been arrested or detained should be produced before the magistrate within 24 hours of his detention. 24 గంటల లోపు ఆ డిటైన్ చేసిన వ్యక్తిని మనము మెజిస్ట్రేట్ ముందు తీసుకురావాలి. సో ఇన్ దాట్ this 24 hours excludes the time of journey but includes all holidays. సో ఒకవేళ 24 గంటల లోపు ఆ మనిషిని కోర్టు ముందు కానీ మెజిస్ట్రేట్ ముందు కానీ ప్రత్యక్షపరచకపోతే, if we are failed, if that enforcement agency fails to produce a person in front of the magistrate, then that person should be left or that will be a illegal detention. So if something happens like that, if a person is detained illegally and kept under detention for more than 24 hours, any person could approach Supreme Court or High Court saying that that particular person has been detained illegally. Then the court will issue writ to that concerned person to bring the body, otherwise to produce that person, that detained person, in front of the magistrate. So this writ is very important for the protection of against illegal detention. So when we say we have a liberty, we have a freedom to move anywhere. For example, in Article 19 Clause 1, we have a fundamental right to move anywhere in entire territory of India. So if someone is detained, that article is being violated. The person's liberty is being violated. That is the reason the court will interfere and issue writ to bring that person before the court. So this is used, the writ, habeas corpus is used to enforce the fundamental right of individual liberty. As we said, we have liberty. Every citizen has a liberty to move freely. And we also have a fundamental right against detention. So if anyone is illegally detained, obviously their individual liberty has been violated. And whenever the individual liberty or a fundamental right has been violated, it is the duty of the court or the judiciary to protect such person or to restore or to enforce the fundamental rights. Because Supreme Court is the ultimate authority which guardians or which protects the Constitution. So because we have writ of habeas corpus, and it could be issued by both Supreme Court and High Court under their exclusive jurisdictions. Orders one person who has arrested another person to bring the body of this person, arrested person, that is later person, before the court. So Supreme Court or High Court ఒక ఆదేశం ఇస్తుంది, అలాంటి వ్యక్తిని ఎవరైతే అరెస్ట్ చేయబడతాడో, డిటైన్ చేయబడతాడో అలాంటి వ్యక్తిని కోర్టు ముందు ప్రవేశపెట్టాలని ఒక నోటీస్ పంపుతుంది. సో దట్ ఈస్ అ రిట్ విచ్ ఆర్డర్స్ a person who has detained another person illegally to produce that person in front of the court. So that is the habeas corpus, that is to bring the body in front of the court. So we have to know what these facts about habeas corpus is. So Supreme Court or High Court can issue these writs against both private and public authorities. What we need to understand is, when we say few writs are issued against private and against public, all writs are not issued against private authorities. So there is a distinction. But habeas corpus, because is a fundamental right for anyone to have individual liberty, or any person has a right to move freely, if such right is taken away by the action of some agency, some enforcement agency, then this writs can be issued. Be it public agency or private person, this writ can be issued against private person also. It is not that only police agency. For example, when we say enforcement agency, it could be state police, it could be ACB, CBI, NCB. So all these enforcement agencies are obviously they generally detain a person, but any private person also involved in detention of a person is liable, or it's liable to get this writs. That is, both private and public authorities are liable. So court could issue the writ of habeas corpus to both private and public authorities. Second thing is, the habeas corpus cannot be issued in the following cases. So we need to be very clear that habeas corpus is a writ against illegal detention, and it can be issued to both private and public authorities. But we also need to know that under which cases, under which circumstances habeas corpus cannot be issued by the court. So we say that it is issued by the Supreme Court or High Court when there is illegal detention, when the detention or arrest of a person is unlawful. అలాంటి ప్రత్యేక పరిస్థితుల్లో మాత్రమే సుప్రీం కోర్ట్ కానీ హైకోర్టు కానీ ఇలాంటి రిట్స్ ఇష్యూ చేస్తుంది, జారీ చేస్తుంది. కానీ ఎనీ సర్కమ్స్టాన్సెస్, దట్ ఈస్ ఒక లాఫుల్ డిటెన్షన్ ఉంటే, లేదా ఒక కోర్ట్ డిటైన్ చేయడానికి పర్మిషన్ ఇస్తే, అలాంటి సందర్భాల్లో ఈ రిట్ ఇష్యూ చేయలేరు. బికాజ్ అది లాఫుల్. కోర్ట్ ఒక డిటెన్షన్కి ఆర్డర్ ఇస్తే అది లాఫుల్ అవుతుంది. కానీ కోర్టు చెప్పకుండా ఒక మనిషిని ఎవరైనా డిటైన్ చేస్తే అది అన్లాఫుల్ అవుతుంది. సో అండర్ లాఫుల్ సర్కమ్స్టాన్సెస్ దిస్ రిట్స్ కెనాట్ బి ఇష్యూడ్ బై ద కోర్ట్. సో వెన్ ద డిటెన్షన్ ఈజ్ లాఫుల్, we can say that, for example, we have a clause of preventive detention. Preventive detention, ముందస్తు అరెస్ట్ చేస్తారు. అక్కడ ప్రివెంటివ్ డిటెన్షన్లో ఎనీ సిటిజన్ అతను ఇల్లీగల్ యాక్టివిటీ చేయకుండానే డిటైన్డ్ అవ్వబడతాడు. రీజన్, ఫ్యూచర్లో ఎలాంటి క్రైమ్ చేయకుండా నివారించడానికి అలాంటి ప్రత్యేక ప్రొవిజన్ మన కాన్స్టిట్యూషన్లో ఉంది. We have a concept of preventive detention to arrest a person on the basis of suspicion. A person can be arrested before he actually involves into any crime, before that person is tried, or before the court punishes him. So that is preventive detention. that is provided in our constitution, and if any person is detained on the basis of preventive detention clause, then no one could move the court asking that that particular person has been detained unlawfully, because preventive detention is a measure or a provision provided in the constitution on the grounds of sovereignty of the state, security of the state. We have many other things. So when detention is lawful, court cannot issue the writ of habeas corpus. Second thing is, when the proceeding is for the contempt of a legislature or a court, ఒక ప్రొసీడింగ్ నడుస్తుంది, ఆ ప్రొసీడింగ్లో ఒక పర్సన్, దర్ ఇస్ అ కేస్, a person has violated or he has made a contempt of legislature. లెజిస్లేచర్లో ఏదైతే ప్రివిలేజెస్ ఇచ్చారో దాన్ని బ్రీచ్ చేయడం కానీ, లెజిస్లేచర్ని బ్లేమ్ చేయడం కానీ, కోర్ట్ రూల్స్ని బ్రీచ్ చేయడం కానీ, సో ఎనీ యాక్షన్ విచ్ comes under the contempt of legislature or a court, then such person is detained, and that person cannot move the Supreme Court that I have been illegally detained. So when there is a proceeding for contempt of legislative thing, that is maybe parliament or state legislative assemblies or any court, this can be any court, if any person detained for this reason of contempt of court cannot move the court for issuing this writs. That is one thing. And when the detention is by a competent court, when any court issues orders for his detention or for a person's detention, then such person cannot approach the court and ask for remedy under Article 32. That is, cannot go for issue of the writs, cannot ask the court to issue the writ. So when the detention is by a competent court, obviously when there is a court and some person has done some crime, the court will order a sentence or punishes a person, and that particular person be sent to jail, be it police custody or judicial custody. In such circumstances, the person cannot move court. When detention is outside the jurisdiction of the court, that is, that particular court can only issue writs of habeas corpus when the matter comes under its jurisdiction. ఆ టెరిటోరియల్ జ్యూరిస్డిక్షన్లో ఒకవేళ ఇష్యూ ఉంటేనే కోర్ట్ రిట్స్ ఇష్యూ చేయగలదు. ఆ జ్యూరిస్డిక్షన్కి అవతల ఏమైనా జరిగితే ఆ పర్టిక్యులర్ హైకోర్ట్ జ్యూరిస్డిక్షన్ అనేది కోర్ట్ ఇష్యూ చేయలేదు. ఫర్ ఎగ్జాంపుల్, సుప్రీంకోర్ట్ అనేది సుప్రీంకోర్ట్ జ్యూరిస్డిక్షన్ ఇండియా మొత్తానికి వర్తిస్తుంది. స్టేట్ హైకోర్ట్స్ జ్యూరిస్డిక్షన్ మాత్రం ఆ స్టేట్ వరకే పరిమితమై ఉంటుంది. ఒక క్రైమ్ ఫర్ ఎగ్జాంపుల్ తెలంగాణలో జరిగితే High Court of Andhra Pradesh cannot issue writ because it is not under the High Court jurisdiction of Andhra Pradesh. So in such circumstances also, High Court cannot issue writs because it is not under the jurisdiction of that state or that state High Court. So these are the four things where habeas corpus cannot be issued. It can be issued against both private and public authorities, but it cannot be issued under these conditions. It cannot be issued when the detention is lawful, that is legal. It cannot be issued when the particular person has made a crime in terms of contempting proceedings of legislature or a court. The court cannot also issue writ when the person is detained by a competent court. And finally, that court should be within the jurisdiction. The issue should be within their jurisdiction. Otherwise, if there is extra jurisdiction, that court also cannot issue writs. This is an example of habeas corpus. For example, a police officer arrested a person and kept in a custody without taking remand from the court, that is, without taking permission from the court for the detention of that person. So this becomes illegal, that is unlawful detention, because here we say few days, but it's only 24 hours. Within 24 hours, that particular person who has been detained need to be produced before the magistrate or court. Otherwise, it would come under unlawful detention. Here in this example, if a police officer detains a person for a few days, so obviously that police officer is doing a mistake here. So that aggrieved person could approach Supreme Court or High Court to take action against this police officer. So according to procedure, arrested person to be produced before the magistrate within 24 hours of arrest. So in this example, Supreme Court or High Court can issue writ to the particular police officer to bring that detained person before the court. So that is habeas corpus, to produce the body before the court. So this acts as a deterrent to any enforcement agency or any person, be it public or private person, to not illegally or unlawfully detain any person. We see many cases of kidnapping. It is also a sort of detaining a person without his willingness. So that person is also liable to be issued a writ, because that is an illegal detention, and kidnapping is an issue where public authorities or private authorities may participate. So this writ acts as a deterrent, that is, it acts as a deterrent against those persons to do any crime or to detain any person illegally. They have to keep in mind that there can be issued a writ against their action. This writ can be filed when liberty is deprived during emergency. So during emergency, under security laws, this writ can be filed. We have a Supreme Court judgment. All the judgments we would be discussing later. So that is habeas corpus. We have another writ of mandamus. Mandamus means we command. It's a command by the court to any body or any organization or a person. So here this writ can be filed against. In habeas corpus we have seen it could be filed against both private and public authority. This writ of mandamus can be filed against only public authority or any corporation, but not private authority or private person. So who are liable to be issued this writ? Public body, that is state, government, department or any such things. Corporations, even corporations or companies under the state are liable to be issued this writ. Inferior courts also, tribunal or government. Tribunals are quasi-judicial authority, quasi-judicial body, but not against private party. The writ of mandamus cannot be issued against private person. So a private individual cannot be issued this writ. So a court should not issue this writ against a private individual. So mandamus cannot be issued in the following cases. We have seen to whom these writs can be issued. That is, we have public authorities, that is department, states. We have tribunals. We have judiciary, that is inferior courts. But this mandamus, this writ of mandamus cannot be issued against such cases, if any department or any agency which do not have a statutory status or any such authority which is not backed by the force of the legislation, such authorities are doesn't come under this writ. So Supreme Court or High Court cannot issue a writ for such organizations or agencies which do not have a statutory status or statutory backup, does not possess statutory force. These things doesn't come under the writs. So discretionary and not mandatory. So we have a provision of issuing this writs. It's not mandatory on the part of the court. To enforce the contractual obligation, we cannot issue this writs to enforce the contractual obligation. When we say contractual obligation, it may be an agreement, a bond, or something of that sort which is agreed between two parties. So under that obligation, that is contractual obligation, the writs of mandamus cannot be issued. And the mandamus also cannot be issued against constitutional authorities like President, governors, Chief Justice of High Court acting under judicial capacity. So judges, president, governments, they are constitutional authorities and they are immune from be getting issued these writs. So president, governors and chief justice and other authorities will not come under these writs. So mandamus is what we command. The court will command, that is, it will give order. So when any person having some duty to do that work, and when he fails to perform such duty, the court will command that person to perform the duty for what he has been there. So command ante oka order, oka vyakti ఆ పని కోసమే అక్కడ ఉండి ఉంటే by deliberately he is there to work such duty, అలాంటి డ్యూటీ పర్ఫామ్ చేయలేని పరిస్థితిలో కోర్ట్ ఇష్యూస్ చేయొచ్చు రిట్స్ని. నువ్వు అక్కడ ఉన్నావు దో యూ హ్యావ్ టు పర్ఫామ్ దట్ డ్యూటీ అని. సో ఫర్ ఎగ్జాంపుల్ వీ హ్యావ్ a person A applied for a construction of house. He has to get permission from municipal corporation, but the authorities of that municipal corporation have not given them the permission to construct the house. So there is a lot of delay in giving a permission. All the papers are clear. That particular person who has applied to construct a house has a clear papers, but due to lack of knowledge on the part of the officer who is working in municipal corporation, he may be issuing or he may be getting that writ to perform his duty. The court will order such officer to perform his duty because he has not performing his duty as mandated by their service or their department. So in that cases, by the writ of mandamus, the court will order such public authority to perform his duty. So that is what mandamus is. The court is commanding when a particular person fails to perform his duty. This writ by the court makes that person to perform his duty. So writ of prohibition. Third important writ is prohibition, that is to prohibit, to forbid, to stop. This is an important writ issued by the superior court to the inferior courts. So literal meaning of prohibition is to forbid. Court that is higher in position can issue writs to the courts at inferior level, preventing such courts to stop the proceedings there. For example, if any petition is filed in district court, and that aggrieved person is not happy with the way the court is functioning on that particular proceedings. So that aggrieved person could also file a case on higher court, case to the higher courts regarding his proceedings. That particular higher court could issue a writ in the name of prohibition to stop the lower court on such proceedings. So basically this writ of prohibition is issued by a superior court to the inferior court. Reasons may be varying when that particular court or inferior court is not in the capacity of dealing with such cases, or when the jurisdiction is crossed, or when it is having an extra jurisdiction. Then this high court or higher court could issue the writ to the lower courts to stop such proceedings. That is what forbid is. Prohibition in further dealing of the case. So writ of prohibition can only be issued against judicial and quasi-judicial authorities. When we say superior court and inferior court, only judicial or quasi-judicial authorities, under this prohibition only writs are issued to judicial and quasi-judicial authorities. When we say quasi-judicial, tribunals are there. Tribunals are quasi-judicial authorities. This writ of prohibition cannot be issued against administrative authorities, cannot be issued against legislative bodies or private individuals. When we say administrative authorities, as in earlier example when we said mandamus is issued to a police officer or any public authority, this prohibition cannot be issued against administrative authorities. This also cannot be issued against legislative bodies, that is parliament or assembly or such thing. This also cannot be issued against private individuals. As we have seen, writ of habeas corpus can be issued against private individuals. Writ of habeas corpus can also be issued against administrative authorities. But writ of prohibition is only between judiciary authorities, both judiciary and quasi-judicial authorities. That is inferior court or superior court, that is high court or supreme court, can issue writs to lower courts, that is district courts or any such lower courts. So it is between judiciary only. So we need to remember this: administrative authorities, legislative bodies and private individuals are exempted. The writ of prohibition cannot be issued to such bodies. The prohibition is a writ which is not issued against administrative authorities, legislative bodies and private individuals. So when we say writ of prohibition, we have an example of that. For example, prohibition is to forbid, and it is a writ issued by a superior court to the inferior court. ఒక పై స్థాయి కోర్ట్ కింద స్థాయి కోర్ట్కి ఇష్యూ చేయబడుతుంది ఈ writ. అవి చాలా కారణాలు ఉండొచ్చు. There may be many reasons. For example, here in this example, if a crime happens in some other state, for example, a murder has been committed in Vijayawada, and the court at Hyderabad has entertained that case, the aggrieved person can move higher court that there is a lack of jurisdiction. So the superior court can issue a writ to the court at Hyderabad to prohibit such case, to stop the proceedings. So here the higher court has been issued a writ to the other court, quoting that you have no jurisdiction to proceed with such case. So it is between two judicial bodies, that is superior court and inferior court. Here the court at Hyderabad has no jurisdictions as the crime has happened in other place, that is Andhra Pradesh. The Andhra Pradesh High Court can only have the authority, High Court or any other court have the authority or jurisdiction to proceed with such case. So prohibition is a writ issued by superior court to inferior court to prohibit with such proceedings.